Yeah. Ain't nobody talking.
Wait, say again? Good morning, everyone. So if you're new to Zoom, here's a couple of things I want to just share with you. Or even if you're not new to Zoom, this is for everyone. Zoom court is tantamount to being in an actual courtroom. So there's a few expectations that I have. Number one, please keep your microphone muted. Unless you are actually speaking, please just keep your microphone muted. If you are not sure how to do that, just take a moment and familiarize yourself with your device. There's a little microphone, looks like the shape of a microphone. You just simply tap on it to mute yourself and untap it to unmute yourself. Very easy, very straightforward. Another expectation I have is that when you are speaking, if it's your case and you are the defendant, I need you to state, after your attorney has stated your name, I need you to state your name. And I need your video rolling. So take a moment to familiarize yourself with your video so you know how to do that. There's something in the shape of a camera, you just tap on that and your video starts. Here's another thing. If you, please keep your microphone muted. And if you are going to be handling some personal business, you can actually still stay on Zoom, but just mute your microphone and turn your camera off. And we will never know what you're doing. Kind of the beauty of being in Zoom. We do not want to hear your personal business. That would include going to the bathroom or having, that would include going to the bathroom or any other things that are out of the ordinary. I would also expect that you would wear clothes. Please make sure you are wearing clothes when you are in Zoom court. And also that you're not sleeping with your video showing you sleeping or lying in bed. So with that being said, let's see if we can call some cases here. Calling to the defense attorney, if you don't hear a prosecutor, state their name, then we will pass on your matter. No, nothing personal, but we have to have both prosecution and the defense. So please make sure you wait for the prosecution first, and then after you put your appearance on, I'm speaking to the defense attorney, please make sure you allow your client to put their name on the record. Do not assume that I know what they look like, if they're here, if they're not here, if they're in custody, or if they're out of custody. I kind of need you to fill in those blanks. If they're not present in Zoom, please do ask whether or not you're seeking to waive their presence. Okay.
Ms. Henry, I have you checked in on Malik Harris. Do I have all parties on Hill, Ronald Hill?
You do, yes.
Yes, ma'am.
Okay. Calling parties on Hill. Case number 2159543. The people of the state of Michigan versus Ronald Hill. The defendant is charged with count 1, homicide, murder, first degree premeditated. Count 2, weapons, firearms, possession by felon. Count 3, weapons, carry concealed. Count 4 and 5, weapons, felony firearm. Habitual offender. Third defense notice. This matter is scheduled for a preliminary exam.
Thank you. Appearances, please.
He's in custody.
I think it's a PCC, but good morning, Your Honor. Mike Glenn for the people. My P number is 77516.
And good morning, Judge Renee Cooper, 30566 for the defense. My client is not on Zoom. He's unfortunately a resident at the Wayne County Jail, and I'd like to waive his presence to set this exam, if that's okay with you.
Sure. If you are comfortable doing so, you've been in communication with him?
Oh, yes, I was, in fact, just yesterday, I spent about an hour with him at the jail.
Okay, all right, well then I will waive his presence for purposes of scheduling. And are there, well, let me just see for a second here. How many proposed witnesses do you have?
Judge, I think that there are going to be 5. I may be able to do it in 4. I guess it just depends on, what the witness testimony is.
Okay, so we will need an afternoon, Madam Clerk. I know we don't have anything soon, so is it possible we can kind of go day by day to see what non-custodial matter we can bump? Starting with, let's see, today's the 2nd of August. If you can look the week of August. Well, let me ask, sometimes there's issues with discovery and whatnot. How early would you be ready to go, prosecution and defense?
So, Judge, I'm in the unenviable position where I'm still collecting some of the body cam from the Detroit police that I'm going to be handing over to Mr. Cooper. I emailed some of the discovery, not all of it, to him yesterday, but we have been speaking, and we're going to meet up either tomorrow or Wednesday so that I can get an external hard drive, and I'll be able to provide the discovery to Mr. Cooper.
Okay, so you would be ready to go as early as the week of August 16th? Or the week of August?
I would think that the following week is probably a better indicator of when I think both sides would be ready.
Okay, August.
I agree with that, Judge.
Okay, thank you. So, yeah, Tammy, I know we're filled through like September, but if we have, I'm saying it more so for their benefit. If we have a non-custodial matter that's in the afternoon that we can bump, that's what I'm kind of looking for.
We have 8/26 open.
August what?
The bond date is scheduled at 1:30, but it looks like he's out on bond.
He did bond out?
Yes.
And we're sure of that.
From the information in the file. Yes.
Okay. Then yes, August 26th at 1:30, would that be a viable?
Judge, I have I have an exam before Judge Jefferson at 1:30 on August 26th.
Okay, next available.
If I heard August 30th, we can barely hear you, but I thought I might have heard August 30th. That would be fine.
No, you didn't hear
Oh.
that.
Okay,
I haven't got-
excuse me. Okay.
We do have. We already moved this once for that same purpose though, but I guess we can move it again.
What's the name of it?
DeMarco Gibson.
Who's defense counsel? What sort of charge is it?
It's Mr. Green. Controlled substance weapons.
At 1:30?
Yes. So I'm not sure why that is.
Yeah. What date is it?
August 30th at 1:30.
August 30th at 1:30. Mr. Glenn?
If that works for Mr. Cooper, I can do that.
That works really well for me.
Okay. We'll set it then, August 30th at 1:30. And again, some discovery, from what I understand, has been tendered, but it's sort of an ongoing process right now.
That's
That's
correct.
correct, Judge.
Thank you. If there's any concerns, Mr. Cooper and Mr. Glenn, if there's any concerns or you have any hesitation about actually proceeding on the 30th, as you can see, we're jam-packed. If you don't think it's going to proceed on that date, please send us a smoke signal so we can fill somebody into that spot or put the matter that was there back into that spot. Because we are really kind of struggling to accommodate all of these matters. But if we're securing that date right now, so it's good for us. Just let us know if on your end you need to alter that.
No problem, Judge.
Of course, Judge.
Okay, anything further?
Nothing
No.
from the people, Judge. Thank you.
Thank you much.
All right. Thank you.
I'll
Good to
call
see
you later, Mike.
Sounds good, Mr. Cooper. Have a great day,
All right.
everyone.
You
Everybody
too.
have a pleasant day.
You too.
Calling parties on Huffman. Case number 2159747, the people of the state of Michigan versus Tyrone Kevin Huffman. The defendant is charged with count 1, stalking aggravated. This is scheduled for a probable cause conference.
Thank you. May I have appearances, please?
Good morning, Your Honor. Jacob Bloomers, P77307 on behalf of the people.
Mr. Bloomers, can I trouble you to
Yes.
jiggle your audio a little bit?
I'll see what I can.
Yeah, we're having that same issue from last week. Defense counsel? Is defense counsel here on Huffman? Okay.
All right, I'll recall it. Calling parties on Hardwell. Case number 2158328, the people of the state of Michigan versus Gerald Leonard Hardwell. The defendant is charged with count 1, stalking aggravated, count 2, malicious destruction of personal property, $1,000 or more, but less than $20,000. This is scheduled for a probable cause conference.
Thank you. Appearances, please.
Good morning, Your Honor. Jacob Bloomers, P77307 on behalf of the people.
Your Honor, may it please the court, Wayne Frost, P51457, representing Mr. Hardwell, who is on Alcatel Joy Tab 2.
Okay, could you state your name, Mr. Hardwell?
Gerald Leonard Hardwell.
Thank you. So today is the date and time set for a PCC. Counsel, what's your pleasure here?
I would like to start a live exam, Judge.
All right. Your client, well, is not in custody. Mr. Bloomers, do you have any concerns regarding bond that would affect the timing of the exam?
No concerns at this time, Judge. The people are satisfied. And this is a second PCC, and there have been no issues since the first one.
Okay, good, thank you.
And Judge, just so
Yeah.
everyone knows, Mr. Bloomers did send me paper discovery in the past. I did not open it in time. If he could send that to me again. He did just send me video discovery that I've not opened yet, but yeah, I did get that approximately 20 minutes ago or something like that. So if he could send me the paper discovery again, I would appreciate that.
Mr. Bloomers?
Yeah, that's not a problem, of course. I will send that just a couple minutes here.
Thank you.
October 25th at 10:30.
I'm sorry, what day was that?
October 25th at 10:30.
That'll be fine.
Okay, in-person exam, October 25th at 10:30. Keep in mind, Mr. Hardwell,
Yes,
This is
Your
a-
Honor.
this is an in-person exam. So
Uh-huh.
please do not appear in Zoom like you are right now. We need you here inside of the courthouse, 36th District Court. You understand?
Yes, Your Honor. You said the 25th?
October 25th at 10:30.
Okay, yes, Your Honor.
Also, please make sure that you continue to abide by the provisions of your bond, which include no contact with the complaining witness, not directly or indirectly. Do you understand that, sir?
Yes, Your Honor.
Okay, perfect. We'll see you on October 25th, sir.
Mr. Frost,
And I'll be talking to you.
Mr.
Yes.
Frost, I
Yes.
just want to let you know there actually is a copy of all the paper discovery in with that digital I just resent, so you should have everything.
Thank you very much. Appreciate that.
Calling parties on Wilson. Case number 2157980. The people of the state of Michigan versus John Wilson. The defendant is charged with count 1, weapons carried concealed, count 2, weapons, firearms, possession by felon, count 3, weapons, felony, firearm, habitual offender, fourth offense notice. This matter is scheduled for probable cause conference.
Thank you. Appearances, please.
Good morning, Your Honor. Rima VP 82800 on behalf of the people.
Your Honor, may it please the court, Wayne Frost representing Mr. Wilson, P51 457. Unfortunately, Judge, the phone number I have for Mr. Wilson is not good. I did send a letter and I have had no response. So I don't know where we're going to go with this, Judge. He's out on a personal bond according to my appointment slip.
Okay, let me just check something really quickly. Well, it looks like when I look back at the notations in the file on June 24th, that was the first PCC.
Yeah, that's correct.
And it looks like, if I'm reading the note correctly, that Mr. Wilson did appear then.
Ain't talking about you, are they? Your name ain't Wilson, is it?
Oh, no.
Oh, okay, well, they ain't ready for you yet.
Right. My teacher's on.
Mm-hmm, yeah.
Okay, so if everyone would be so kind. Mark Malone, including you, good morning to you, but if you could keep your microphone muted, that would be most helpful. Mr. Frost, I'm sorry, did you say you've had no contact with him at all, or you just have not?
I have not, Judge. The phone number I have is not a valid phone number, and I did write him a letter, and he has not responded to the letter at the address that I have for him. So I have not contacted him. I may have waived his appearance at the first hearing. I am not sure, Judge.
I like to. That's what. it
Thank
says,
you.
but that's-
I just was trying to read the note. I
That's
just
not
wanted.
what it should have said, Judge. He did not.
Oh, okay, all right. Okay, so today is not just the first PCC, but it's the second PCC. And, you know, I generally don't have a problem with waiving a non-custodial appearance in the when there is communication that's represented by counsel. But in this instance, not only did the defendant not appear on June 24th, but here we are a considerable time.
And call
Okay, so what I'm going to start doing is putting everybody in a waiting room because we cannot hear. So if you find yourself suddenly in a waiting room, no worries. We'll bring you in when we need you. I know it can be tricky trying to keep your microphone muted. But we're just going to do this so that we don't have this issue anymore. Yes.
The court also sent a notice to him.
Oh, good. Thank you for stating that. Okay, Madam Clerk just indicated as well, want the record to reflect that a notice was sent to the defendant's last known address at least, regarding today's appearance and the need for him to appear via Zoom. And he is not here. It's currently 9:37 by the court's clock. This matter was set for an 8:30 conference. And have we received a phone call from a Johnny Wilson?
No.
And coupled with the fact that counsel has also indicated that he's made efforts to communicate, correspond with the defendant to no avail. Madam Prosecutor?
People move for a case, Your Honor.
KPS is going to issue. In the event that you are able to get in touch with your client, please, if it's before noon, before the lunch hour, just zoom in and we will have not even entered the KPS by that point, and we'll just formally set it aside and get this back on track. But if it's after today, then he will have to avail himself in the normal course of business with an open warrant.
Thank you, Judge.
Oh, I should also state, sorry, that the previous bond is revoked, which was what? You indicated it was a personal bond, and I don't have the pretrial release order form here.
I do not either. However, my appointment slip says 10,000 personal.
Okay, bond is going to be, new bond is going to be set at $10,000 cash or surety. And did you have any more matters here, Mr. Frost, or is that it?
I do not, Judge. Thank you.
Okay, thank you, sir.
Parties on Perry Bay. Case number 2157783, the people of the state of Michigan versus Edward Perry Bay. The defendant is charged with count 1, weapons, firearms, possession by felon. Count 2, weapons, felony, firearms, second offense. Count 3, telecommunications services, malicious use. Count 4, telecommunications services, malicious use. Habitual offender, fourth offense notice. Judge, this is scheduled for a motion hearing.
Thank you. Appearances, please.
Good morning, Your Honor. Remind me, on behalf of the people.
And good morning, Judge. Neighborhood Defender Service by Jackie Pilkowitz, P81653, on behalf of Mr. Perry Bay. Is he? Did you pop him in the waiting room by chance? He had been here all morning, so I can give him a call if he's no longer here.
I did. I'm sure I did. I put everyone into the waiting room because people don't know how to use their device properly. So let's see. What is his name again?
Amin Perry.
Okay, here we go.
Thank you, Your Honor.
Mr. Perry, are you there with us?
Yes. Yes, I am.
Sorry, and can you state your name, please?
No.
No?
That's his hand.
Oh. Amin Perry.
Yeah, I'm here. I'm here.
Oh, okay, please state your name.
Jamin Perry Bay.
Thank you. Counsel, what's your pleasure here today?
Judge, I believe the court is in receipt of our motion for permission for Mr. Perry Bay to leave the state for work-related purposes. Mr. Perry Bay is currently on a tether and has been for the past few months. He has had absolutely no issues, as far as I'm aware, on his GPS tether. He works as a photographer for a company called Atelier 041. It's a talent agency in Detroit. And it's my understanding that they have a work-related function. I believe it's a photo shoot, and perhaps Mr. Perry Bay can shed more light on that, in Miami from August 12th through August 15th. So we are asking for the court to sign off on an order permitting him to leave for that purpose. And of course, with the GPS tether, I don't believe there would be any issues with him crossing state lines as long as the court signs off on it. But of course, the GPS tether keeps in place that, the court will be aware of his whereabouts. And given that it is for work, we're asking for the court to sign off on that.
Madam Prosecutor?
I have no objection to that, Your Honor.
Okay, I do see the motion here that articulates the time frame, August 12th through August 15th, as counsel's just indicated, for work purposes. Certainly, I want him to be able to take advantage of whatever employment opportunities are there for him. But what is missing are the particulars. I have the time frame and I have the city, Miami, that he's going to, but I don't have any flight information. I don't have where he's staying in Miami. So I would need, in order for me to sign off on that, I would need those particulars. Flight, the airline and the flight number for the departure and the return. And if he's staying in Miami proper, I need the actual location of where he's staying.
Understood, Judge. And I'm guessing that perhaps he has not yet booked his flight in light of the fact that he was waiting on the court's ruling. But if that's not the case, either way, I will get the court the flight information. And just to confirm, Mr. Perry Bay, while you're on here, it's the 12th to the 15th. That's correct?
Yes.
Okay. Judge, if I get you a proposed order this afternoon, would the court be inclined to sign off on it with those details?
Yes, and just like what I do want to be clear on, I don't want to make it seem like I'm hedging on whether or not I'm going to approve it. I will approve it, but it's an if then. So in order for me to actually affix my signature, I will need those specifics.
Understood.
I don't want you or him to think that if he buys the ticket and provides the information, then I may not approve it. I will, but I won't sign it until I have those details.
Sounds good, Judge. Thank you.
Oh, and the record, again, I do want to reiterate that the prosecution has indicated that they have no objection to it as well. So with that being said, we'll look for that proposed order. If you could forward it to Madam Clerk, that would ensure that I don't miss it in my email here, and I'll sign it once it's received. If you could also shoot a copy over to Madam Prosecutor too.
I always do, Judge. Thank you.
Thank you.
All right. I mean, you can sign out and we'll chat about the details. So I'll give you a call.
All right, thanks.
Thanks, Judge.
Thank you.
Is there a future date on this?
December 1st at 11:30.
Thank you.
Calling parties on Lewis. Case number 2060462. The people of the state of Michigan versus Nathaniel Lewis. The defendant is charged with count 1, stalking aggravated, count 2, breaking and entering illegal entry without owner's permission, count 3, malicious destruction of building less than $200, count 4, domestic violence. Second offense notice. This matter is scheduled for probable cause conference.
Thank you. Appearances, please.
Jacob Bloomers on behalf of the people.
Ms. Perkins? We call it. Ms. Perkins Moore? Okay. Do I have the parties on Harris, Malik Harris?
I'm here.
Case number 2159451, the people of the state of Michigan versus Malik Harris. The defendant is charged with count 1 and 2, police officer assaulting, resisting, obstructing. This is scheduled for probable cause conference.
Good morning, Your Honor. Kathy Henry, appearing on behalf of Mr. Malik Harris.
Good morning, Your Honor. Rima Kufi on behalf of the people.
Good morning. Is Mr. Harris here?
He had signed it earlier, I think. He's in the.
You did check in earlier? Oh, there he is.
Okay, I don't know if your client is here, but did you
I'm
want
here.
to ask? State, I'm assuming you know what he looks like, and if he's here, did you want to ask your client to state his name?
Mr. Malik, if you are present, could you state your name? I haven't had any contact.
Malik Harris, are you present? Okay, so if you found yourself in a waiting room, that was because we had too many microphones that were not muted. So I'm gonna put everyone back in the waiting room because I know it can be a little tricky, but we need to hear. If Malik Harris is not here, Madam Defense, what's your pleasure?
Your Honor, I've had no contact. The phone number that I have got from him from the discovery, it does not indicate, the number is not available. So I don't have any way of reaching him.
All right.
I'd ask for his German just so maybe I can get a letter out to him maybe.
Okay, this is the first PCC, correct?
Yes, it is.
All right, with that being said, I'm going to set this out. I do find good cause to adjourn so that you could have an opportunity to establish contact and determine direction you want to take this. How about August 30th?
That's fine.
That's a month. That's fine?
That's fine.
Okay. New PCC. Do you have discovery?
I do.
Great. New PCC, August 30th at 8:30. That's going to be via Zoom. And we'll see you then.
Okay, thank you. Have a good day.
You too. Thank you.
Parties on Lewis, Nathaniel Lewis. Ms. Perkins Moore? Are you ready on Lewis, Nathaniel Lewis? She must have us muted. Mr. Noakes, are you available on Huffman?
Yes, I am.
Okay. Recalling case number 2159747, the people of the state of Michigan versus Tyrone Kevin Huffman. This case was previously called in full. It is scheduled for a probable cause conference.
Thank you. May I have appearances, please?
Jacob Bloomers on behalf of the people.
May it please this honorable court, William Noakes, P42796 of the Neighborhood Defender Service of Detroit, on behalf of Mr. Tyrone Huffman, who is present via Zoom.
Mr. Huffman, if you can hear us, please state your name.
Tyrone Huffman.
Thank you. Counsel, what's your pleasure?
Your Honor, we've yet to receive discovery in this matter, so I'm asking for discovery, an order of discovery. And also, I'd like you to set an exam, in-person exam in this case.
Okay. Mr. Huffman, can you roll your video?
Yep, 1 second. Oh, shit. Oh, I'm here.
Okay, thank you. Okay, Mr. Bloomers, I know you heard what counsel just said, but he's in need of discovery. Are there any concerns, Mr. Bloomers, regarding the bond that might affect the timing of an in-person exam?
No concerns at this time, Judge.
All right.
And Your Honor, if I may?
Yes, sir.
The one concern I have is the GPS tether. And I'd request a DSU report to determine whether or not the GPS tether is in fact necessary.
Well, I don't know that you're going to get a DSU report back because he's not in custody if I'm looking at the right screen. They won't, is he in custody?
No, ma'am. No, Your Honor, he is not in custody.
Yeah, so they're not gonna kick back a DSU report unless he's in custody. If you wanted to make an argument regarding the tether, you can do so now if you'd like.
Thank you, Your Honor. This is an instance involving a case with a person that Mr. Huffman had been in a long-term relationship with, and the relationship has gone bad. And he had, before this time, Mr. Huffman had been working. He describes himself as being very outgoing and respectful. And he was on certain medication at the time of this incident, a mood stabilizer, which he had apparently not taken. He's the father of 3 children. He has no previous felony history, and he has no intent of going near the complaining witness. And so at this point, he's neither a danger to the community, nor is he a flight risk. And given the fact that he has no intention of being near the complaining witness and would simply be with his children, there's no need for a GPS tether.
Mr. Prosecutor?
Well, Judge, as Mr. Noakes stated, there was a previous dating relationship between the complaining witness and the defendant. The charge here is aggravated stalking, and the facts here have to do with, multiple instances of threatening communication and contact towards that complaining witness, Ms. Irene Slappy. So I think that a tether is absolutely necessary in this case, given this, in addition to the fact that Mr. Huffman is on a personal bond. I don't think a no contact order and a personal bond is sufficient in this case. Again, the aggravated stalking charge especially, it leaves me in a position where I haven't got any attempt to remove that tether.
Okay, given the allegation, well, yes, what I'm gonna do is I am gonna deny them, due to the nature of these allegations. I'm not comfortable, we could go back and forth on the matter, but I'm not comfortable removing the tether. But what I will do is I'll give you an exam date. You said you're looking for an exam date. You're also looking for the discovery. I'll give you an exam date at first week in September if you'd like, which is, really, really early because we're really way out right now, but that's the best that I can do to sort of split the baby, so to say.
Well, that's perfectly fine, Your Honor. I'll take the early exam date.
Okay.
September. 9:30.
Can
September
I ask
1st
a
at 9.
question?
Oh, yeah, yes.
Can you just lift my restrictions of just going to work?
Okay, is it just go to work? Is that it?
Yeah, that's what it was all supposed to be, but can you lift the restrictions of that?
And what would you be looking to lift it to? And
I
for
mean,
what purpose?
because I take my kids back and forth to my auntie house. I still take care of family members, and I still have a lot of things to do during my daily basis besides just go to work, like shopping, clothes, and all that.
Mr.
I mean,
Bloomer?
I'm not trying to go around that Miss Slappy's house or nothing like that.
Mr. Huffman, what would be the hours that you would need the court to accommodate you on?
From 8 a.m. to at least 7 p.m.
Your Honor?
Mr. Bloomer?
The people won't object to modification of the hours from 8 a.m. to 7 p.m.
Say it one more time.
The hours that were just stated, 8 a.m. to 7 p.m., the people have no objection to that modification.
Thank you. Mr. Noakes, given the representations that have been made here, that the prosecution does not have any objection to that modification. So it's the GPS tether, to be clear, Mr. Huffman, is still in place. It's not being removed. However, it's going to be amended. I'm going to sign off on amending it from the restriction that you can only leave your location to go to work. Now it's going to be 8 a.m. to 7 p.m. But to be clear, it is for employment purposes and or family obligations such as child care issues, groceries, things of that nature. It is not for anything outside of that, such as social or anything that would have any relevance to the complaining witness. There's to be no time, not directly or indirectly. So that would include telephone, text, chat, any form of social media outreach. It also includes using someone else to act on your behalf in reaching out to the complaining witness. I also want to be clear that even in the event that the complaining witness comes to you, you are not then permitted to engage with the complaining witness. And lastly, let me emphasize that the consequence, because some people don't think there is a consequence, I'm not sure why, but the consequence of violating the no contact would be that your bond could be revoked. So it's very serious, and I want you to understand the consequences if it's not abided by. So Mr. Noakes, can I trouble you to forward to the court a proposed order to that effect so that I could sign off on it, altering the time frame to 8 a.m. to 7 p.m. for employment and family obligations?
Yes, Your Honor, it'll be later this morning, but I will send that to the court.
Perfect, thank you. And again, we have an exam date that we're looking to set September 1st. Are you available that date at 9:30? I think it was put out there, but I don't know that we confirmed it.
I'm available anytime, ma'am.
Mr. Noakes?
I appreciate that, Mr. Huffman. I'd like to be there too. September 1st at 9:30 a.m., Your Honor?
Yes, sir.
I will be there.
Perfect. Okay, I'll look for that proposed order and we're all set here.
All right, and Mr. Huffman, I'll be in touch. If not today, then tomorrow.
All right, thank you, sir.
You're welcome.
Counsel? Good morning.
Morning, Mr. Dietrich.
What's the name?
Dietrich?
I have it.
Oh.
I'm just trying to see. Miss Perkins Moore? And she must have our sound turned off. And then I have the disturbance. Is this, I was told this was a dismissal. Is that correct? Calling parties on Dietrich. Case number 2061840. The people of the state of Michigan versus Lyndon Thomas Dietrich. The defendant is charged with count 1, weapons carrying concealed. This matter is scheduled for a preliminary exam. Thank you.
Could I trouble you for a bond modification form, just so.
Oh, yeah.
Okay, appearances on Dietrich.
Good morning, Your Honor. Read my on behalf of the people.
Good morning, Your Honor. Spencer Clayton, appearing on behalf of Mr. Dietrich, who is behind me to my right, key number 77302.
Thank you. Could you please state your name, sir?
Lyndon Dietrich.
Thank you. All right, today is the date and time set for a preliminary examination. Are we proceeding to an exam?
Your Honor, at this time, the people are not ready to proceed. Trooper Pearson was subpoenaed and notified to show up to court today and tonight.
Time set for 10 a.m. It's currently 10:01 at this time.
Moving to dismiss, Judge.
Okay, with the representations that have been made here by the prosecutor, I am going to grant that motion that's been made to dismiss this matter. The matter is dismissed without prejudice. So the important thing for you to understand, Mr. Dietrich. Mr. Dietrich, can you hear me?
Yes.
Oh, okay.
Sorry.
Oh, okay, I was just making sure you're.
I can't see who's bouncing.
So, that's true, we do have these masks on. I just want to make sure that you understand, because for the most part, people, when they hear the word dismissal, that's all they're concerned with. So I do like to explain with each and every matter that's dismissed without prejudice, really what that means. That trailer language after the word dismissal, without prejudice, what that means is that the prosecution can reissue. Now that probably strikes you as a little confusing. So I would just ask that you have a discussion with your attorney about what that means, the fullness of that concept. But whenever a matter is dismissed without prejudice, that is within the discretion of the prosecution. If they gain information that warrants such an action, they can reissue this very charge that was dismissed today on August 2nd. Again, I know that can be a little confusing, so please make sure you get any of your questions answered in that regard by your attorney. Particularly in this case where the person that didn't show is an officer, a trooper. Perhaps there could be some reason, that a plausible explanation as to why that officer could not get here today. And in the event that it's reissued, you should understand how that happens, okay? Do you have on a GPS tether that needs to be removed?
No, I do not.
Okay. Counsel, I just need your signature on this order of dismissal as the moving party. And we'll be all set. I'm preparing it right now. Is there anything further from the prosecution or defense?
Nothing from the people, Your Honor.
No, Your Honor. Thank you.
You're welcome. You can have a seat in the hallway, sir. Oh, I do, yeah. Let me see who's there.
I'm not sure. Ms. Perkins Moore?
Yes. She's out there.
Calling parties on Curtis. Case number 2058482, the people of the state of Michigan versus James Paul Curtis. The defendant is charged with count 1, criminal sexual conduct, third degree incapacitated victim. SORA notice, HIV STD testing notice. Judge, this is scheduled for an exam tomorrow, and they have asked me to call it this morning. Thank you.
Appearances, please.
Good morning, Judge. Nita Simonis, Assistant Prosecutor for the People.
Good morning, Your Honor. Michael McCarthy, P30169, appearing on behalf of, but without James Paul Curtis, the defendant in this case.
Okay, and are you requesting to waive your client's presence?
I am, Your Honor. I'm requesting an adjournment. I explained to your clerk and to Ms. Simona, my wife was just released from the hospital late on Friday, having a knee replacement surgery, and I'm her caregiver, and I cannot leave her for an extended period of time. I'm calling her. I'm here at my home today, and what I'm asking is that we adjourn this for a period of time so that I can be available.
And the people have no objection to that. Mr. McCarthy was nice enough to contact me and talk to me about that. I don't know, he's not in custody, so I don't have any problem. I'm gonna be in your courtroom tomorrow anyway, because I have a live exam of an in custody case. So no problem with us picking another date. I can contact my witness.
Okay, thank you. And I certainly do find good cause based on the representation made to adjourn this matter. And please make sure, Mr. McCarthy, that your client is up to speed with what's going on and why the matter is being adjourned, since it was previously adjourned back in March by the court due to congestion of the docket with this pandemic that has affected the timing of everything. So please make sure that your client understands why this matter is now being adjourned again. And we'll set it for, well, he's not in custody, so I'm thinking if there's no concerns regarding bond.
There's not been any since that I've been made aware of, Judge.
Okay, can we find an October or late October date?
October 22nd at 10 a.m.
That sounds very good.
I'm sorry, one more, October, what was it, 20th?
22nd?
At what time, please?
10 a.m.
Okay, so I've got a couple of matters up that are on that morning. Is there anything earlier that week, or, you know, like the 20th or 21st by chance?
Or it might have to be the week after. Because we're
I know, I understand. I totally get it. Okay, let's put it for the 20th, and let me see what I can do about the other things. So the 22nd, October 22nd, which is a Friday at 10 a.m.
Okay.
All right.
All right. In person
Thank you very
exam.
much, Your Honor.
October
I will
22nd.
contact Mr. Curtis.
Okay, and please make sure that he is abiding by any of the provisions with regards to his bond, including no contact with the complaining witness.
Yes, and I can tell you, based on my numerous conversations with him, that he has been doing that very thing, Your Honor.
Oh, perfect. Thank you.
Mr. McCarthy, when I have you on, did you say you were considering an exam by Zoom, or did you prefer a
Well,
live?
I said that for, you know, purposes.
Today, okay.
Yeah,
I
but
get
if we could do it in person, that would be best, I think.
Okay.
Yes, it would.
Thank you.
Thank you.
Thank you, Judge. Thanks,
Take
Tammy, for your help here. Have a
Yes,
good day,
thank you
everybody.
very much.
See you tomorrow.
Bye-bye.
The only thing called right now is Nathaniel Lewis, but I'm not sure why we.
I would have been lost.
Miss Linda Perkins Moore? Are you available on Lewis? It's like she can't hear us.
This is Nathaniel Lewis.
Thank you.
I understand that. We need your attorney.
Please mute your microphone.
Hello?
Hello, please mute your microphone. Thank you.
Okay.
Hey, this is Jamie from Judge Archer. Can you hear us? I'm trying to call your case and it's like you can't hear us.
Okay, and then let me
I'm-
make. I got you now. Okay, thank you. I'm sorry. Bye.
Calling parties on Lewis.
Ready?
Case number 2060462, the people of the state of Michigan versus Nathaniel Lewis. This case, I believe, has been called in full. It is scheduled for a probable cause conference.
Thank you. Appearances, please.
Jacob Bloomers on behalf of the people.
Good morning, Your Honor. Linda Perkins Moore, P36136, appearing on behalf of Mr. Mr. Lee.
Oh, Lewis, can you state
calling case P1073138.
Mr. Lewis, can you please state your name?
Mr. Lewis, state your name. Your Honor, on his behalf, I would just indicate that he's an elderly, and I'm not sure how he's, working with this, but he wishes to stand mute away the phone reading, and we're asking for an adjourned date to get discovery.
Mr. Lewis he's been trying to chime in several times here. Can you hear us,
Right,
Mr. Lewis?
He's been having a problem.
Okay, I will, if you're requesting to waive his presence, I will do so. Please make sure you call him so that he understands.
I will.
What's your pleasure?
Can you hear me?
There he is.
Name, sir.
I need to get discovery and a new date.
Okay, prosecution, can we get discovery to counsel?
Yes, Judge. I actually, I believe Ms. Perkins Moore was newly retained. I just sent the link this morning, so she should have the discovery today.
Okay, thank you.
And then I'll follow up with digital soon.
Okay, and you want an examination date, you said?
Okay, yes.
Mr. Bloomers, are there any concerns regarding the bond affect the timing of the exam?
Judge, and at this time, the defendant is on a $7,500 personal bond with a no contact order. There is no tether in place. However, after reviewing the file, the people are satisfied at this time.
Okay.
October 21st at 10:30.
October 21st, that's fine. Thank you.
Okay, October 21st at 10:30 will be the in-person examination date. And that certainly will give you an opportunity to receive and review the discovery in this matter. And if there's any issues that arise between now and then, please notify the court accordingly, but otherwise we'll expect to see you on October 21st at 10:30. I would ask that you make sure that Mr. Lewis understands that he is to appear in person. Ms. Perkins Moore?
Yes, Your Honor, I have it.
Okay, because so often we have people get confused. Should I be in person or in Zoom? He is to appear in person on that date and should plan to arrive early so that he can afford the opportunity to pass through the screening, which might cause delay. So if he can plan to arrive early, that'd be great.
Okay.
And no contact provision is still in place. Please make sure that he abides by that as well.
Yes, Your
And
Honor.
all set. Thank you so much.
Thank you, Judge.
I think that's it until our 10:30 starts. So I don't know if Ms. Constance wants to take a quick break.
Oh, yeah. Go ahead. You want to take a break?
Okay.
All right. How long? 5 minutes? Or no, you don't have to.
No, I will.
Oh,
We're
okay.
getting ready to start exams though, so we don't.
I'm just saying, what time?
I mean,
Right back.
yeah, like 5 minutes, yeah.
My nose was just, I was doing like
Oh,
this.
got it. Yes, sir. Yours. Yours to enjoy.
Your Honor,
Hello?
Eugene, just go ahead and mute yourself until it's time for our case, okay?
Okay.
Prosecutor?
Counsel, were you checking in on a matter?
Yes, good morning, Judge. I'm here on Eugene Copeland.
That's a Zoom exam?
Yes, it is.
Oh, okay. I didn't get that one. Judge, the 11:30 bugs is a Zoom exam too.
Okay.
So I guess if we're ready to go.
As soon as the prosecutor comes back in, we'll check to see if there's witnesses. Oh,
Okay,
wait a
thank you.
second. If it's a Zoom exam, they would be here. Let
Yeah.
me see if they're here.
Is she out there talking to the other case?
Hello. Ms. Yaldo, you're not driving while you're Zooming, huh?
Judge, I am only because I'm on my way to court for a physical exam, but I am getting ready to pull over so I can do our exam parked, I promise.
Okay. Oh, is this yours?
Yes, this is my case.
Oh, okay. People versus Eugene Copeland.
William Morales Smith, P83353 for people, Your Honor.
This is 210555602.
The people of the state of Michigan versus Eugene Dallin Copeland. The defendant is charged with count 1, weapons carrying concealed. This is scheduled for a preliminary exam.
Thank
My
you.
apologies to the court for being.
No, that's okay. Appearances, again, please.
Lord Morales Smith, P83353 for people, Your Honor.
And good morning, Your Honor. Mallory Yaldo, P79861. I'm appearing on behalf of Eugene Copeland, who's also present via Zoom. Mr. Copeland, will you please tell the court your name?
It's actually Eugene Delon Copeland. Delon.
Thank you. Today is the date and time set for a Zoom examination. Are we proceeding to an exam?
I'm sorry, Your Honor, I didn't realize it was Zoom exam, but we are here and present and ready to proceed.
Yes, Zoom exam. Defendant waived right to an in-person exam on March 10th. Well, I guess that begs the question, are you amenable to a hybrid examination, Madam Defense?
Judge, I guess, I mean, I've never been in this situation, but I don't see why not. What would the alternative be?
An adjournment.
Oh, no, if everyone's there, we can, well.
Any preliminary matters?
Not to the people, Your Honor.
Okay, first
Not
witness.
on behalf of the defense.
Thank you. First witness.
The people call, sorry, Janah.
Okay, please, if you could stand up and state your full name and spell your first and last name for Madam Court Reporter. But you can do it loud for everyone to hear.
Officer Haley Janah. First name is Hayley. Last name Genaw.
Thank you. Please raise your right hand. Do you solemnly swear or affirm testimony you're going to give is the truth, the whole truth, nothing but the truth?
I do.
Thank you. If you could make your way over here to this half gate that will swing open towards you and have a seat. Madam Prosecutor, your witness.
Thank you, Your Honor.
Wait, you know what? I think, can you bring the base this way? Didn't we do that before? I'm not sure how we did it. A little bit, yeah. So the base will come. Oh. That way. I can't use this towards you, like.
I said, no comment. Great.
I don't want that to fall.
Yeah, that's fine.
Is that okay? Okay. Please proceed.
Thank you, Your Honor. Can you please state your name for the record?
Officer Haley Janah.
And were you, I'm sorry, how were you employed?
With the city of Detroit as a police officer.
And were you employed in that manner on January 27th, 2021?
Yes, I was.
And were you on patrol on that day?
Was that what? I'm sorry.
I'm sorry, were you out working on that
Yes,
day?
I was.
Okay. And at that date and time, as you were out, what kind of vehicle you were in?
You were in a marked scout car.
And what were you wearing?
I was wearing these green pants I have on now and a black jacket that said police on it, Detroit Police.
So clearly identified as a police officer.
Yes, ma'am.
And can you tell us what happened at that date and time where you encountered the defendant?
On that date and time, I was on a task force with the ATF. We had an officer that was working in a plane capacity undercover.
If you could, I know you were working with officers, but if you could make sure you confine your answers to the singular.
Okay.
Thank you.
So on that date and time, I was driving the scout car and I was advised by the officers in undercover capacity that he observed a male walking with a handgun that was concealed. So me as the driver, I drove to that area, encountered the male.
Okay, I'm gonna stop you there. You said you encountered the described suspect?
Yes.
And what did you see when you saw him?
So I observed him to blade his body away from us, since it was someone who was concealing contraband.
And what does it mean to blade his body?
So where the gun was concealed, he tried to keep that part of his body away from us, like turn his body.
A turning motion?
Yes.
Okay. And then what happened then?
And then my partner and I stopped the vehicle I was driving. I observed my partner, Theo Scott, engage in a verbal conversation. And then the male stated that it was in his pocket.
Now, did you physically see that?
Did you hear that?
Yes, I heard him say that, yes.
Okay. And did you physically see it?
Yes, I did.
And what did you see?
I saw the hard edge object concealed.
Okay, and, when I say see it, did you see any particular part of the weapon?
I didn't know.
Did you see it in his pocket?
Yes.
Okay. And what did you observe next? If anything?
Then my partner and I exited the scout car, and I observed my partner recover a firearm from this person, and I placed him in handcuffs.
And do you recall what type of firearm that was?
I do not, but I can refer to my report.
Do you have your report there with you?
Yes, I do.
If you would care to look at that and refresh your recollection?
Yes.
And let me know when you are done refreshing your recollection. And all set?
Can you ask the question again, please?
I'm sorry, are you all set?
Yes.
Okay. And did that refresh your recollection?
Yes, ma'am.
Okay, and what type of gun was that?
It was a Smith & Wesson Shield 9mm.
Okay. And did the defendant, I'm sorry. And did the defendant have a CPL?
No, ma'am.
And you verified that? Or did
I did not, my partner would have since he was jumping then.
Okay. But that's in your report as DOIC?
Yes, ma'am.
Okay. That he did not have a concealed?
Correct.
Okay. And I'm sorry, what color was that gun?
It was black.
And ma'am, do you see that person that you encountered today?
Yes.
Can you describe what he's wearing for us, please?
He is wearing a white shirt with glasses.
And for the record, the witness has identified the complainant, I'm sorry, the defendant?
The record will reflect the identification of the, well, I just would like, since we're doing a hybrid examination, for you to explain where you see this person.
Yes, ma'am, I see him on the TV screen right now.
Okay, thank you. The record will reflect identification of the defendant.
No further questions at this time.
Well,
I'm sorry, I do have.
Go ahead.
Sorry, I do have a couple more. Was there a body cam of this event?
Yes, there was.
And if you were to play that body cam, would you be able to verify that as fair and accurate at the time?
Yes.
And Your Honor, at this time, I would like to play the body cam.
Okay.
I'm sorry, I gotta get my phone so I can do that. Officer, does this video accurately depict the scene?
Yes, ma'am.
Your Honor, this time, the people would like to play this as, people's evidence, 1.
Madam Defense, any objection?
No objection, Your Honor.
Okay, will be admitted as People's Exhibit number 1. Please publish it.
Thank you. What was that, ma'am? Is that the gun recovered?
Yes, ma'am.
I'm gonna stop this video. Back it up just a second.
Is that considered illegal if it's purchased in my name? Is purchased in your name?
Okay.
Yeah. Okay.
And then, can you see the screen there? All right, I'll put the. All your citizens. Do you see the screen there?
Yes, ma'am.
And can you see the gun in that screen?
Yes.
No further questions, Your Honor.
Where do you see it? In his jacket pocket? Thank you. The question I was going to ask you, however, Officer Janelle, is it Janelle or Ganel?
Janelle.
Janelle.
Yes, ma'am.
What did you do with the firearm?
It was placed on evidence.
Wait, did you recover it or your partner?
No, my partner.
And what did you see happen with it?
What do you mean?
Oh, I'm sorry, if you could just,
I saw him recover the gun from his jacket pocket.
okay, and you know that it was placed on evidence?
As far as I know, yes.
I mean, it was recovered and not handed back to him, presumably?
Yes.
Oh, okay.
And I'm sorry, as the OIC, is there an evidence tag with that firearm?
Yes.
Can I get that tag number, please? Can I refer to my report for it? Yes, absolutely. So the barcode ID for the firearm is 648849-1. And what was the property number on it? It'll be the report number, so 2101270176.1. Thank you.
Cross-examination?
Yes, Judge, I'm sorry. And Judge, just real quickly, I am at the court. Should I come in or just proceed via Zoom? Thank you.
If you come in, you would not be able to communicate with your client in the event that you need to in a breakout room.
Okay.
Remember, you're with.
Okay, I'll just stay on Zoom for right now. I'm just walking in. But okay, so officer, what was my client doing when you approached him?
He was walking down the street.
Okay, was he doing anything illegal?
Besides concealing the firearm, no.
I mean, but did you know he was concealing a firearm?
Yes, ma'am, I could see it.
You could see it sticking out of his pocket?
I could see the imprint of it, and at that time, the reason we were in that area, my partner and I were advised by a undercover officer who was in the area that he observed him walking with a firearm.
Officer, my question to you is, did you personally observe my client with an actual firearm?
Yes, ma'am.
So you could see through the pocket, you knew that that was a firearm inside his pocket?
Yes, ma'am, that's what I do for a living, yes.
You see through pockets for a living?
I can see an L-shaped bulge that is consistent with the firearm, yes.
In a denim jacket?
Mr. Copeland, don't say anything. Approximately how far were you from my client?
We were driving in the street and he was on the sidewalk.
Okay, and so you saw a bulge in his pocket, correct?
Yes, ma'am.
And it could have been a cell phone or a wallet. Isn't that correct?
That is possible, yes.
Okay, but what I'm asking you, officer, is did you actually visibly see in open plain view a firearm in my client's possession?
That's the crime. It was concealed. It was not in plain view.
Officer, my question to you is, did you witness my client with a handgun in his possession in plain view?
I don't know what she means by plain view.
Can you
What I'm
re-ask
What I'm asking you is, did you witness my client with a handgun in his possession? I'm not asking you what you thought was in his pocket. I'm asking you if you think that you saw a handgun, if you saw my client with a handgun. No. Thank you. Judge, I apologize. I was just gaining entry into the building. So, officer, and I apologize. My question to you is, did you actually witness my client with a gun in his hand?
Objection,
Your Honor. Asked and answered like 3 or 4 times now.
I'm gonna allow the answer.
It was not in his hand, no. It was in his pocket.
Okay. And you said, and I know I asked you this already, but he wasn't doing anything illegal. Is that correct?
Not at that time, no.
Okay. Was he doing anything suspicious?
I can't speak about that.
I'm sorry. The audio kind of cut out. What was your answer?
I can't speak to what you would define as suspicious.
I'm asking you essentially, officer, what was my client doing that got your attention besides being a bulge in his pocket? He was walking down the street. That's correct?
You're correct. He was walking down the street, yes.
Okay. So he wasn't doing anything illegal, correct?
No.
Okay. And was he loitering?
No, ma'am.
Was he trespassing?
No.
Okay. And so let me, what time of day was it?
I can refer to my report if you would like an exact time. It was daylight out.
It was daylight out?
Yes, ma'am.
Okay. So just to clarify, it was daylight out and he was just walking down the street, not doing anything illegal. Is that correct?
Sure, yes.
Okay. And who approached my client first? Was it you or your partner?
It would have been my partner.
Okay. And when you approached my client, what was the first thing you asked him, if you recall?
I don't recall what it was. I know we were in the car, we had a verbal conversation with him, and your client stated it's in my pocket.
Right. So did you just walk up and he made that statement on his own, or did he make the statement in response to a question that you guys asked him?
I don't recall exactly what was asked.
Okay. If you can refresh your memory by checking your report, would that help?
No, it wouldn't.
I'm sorry, you said no?
No.
Okay, but so you're saying that you don't recall what you guys first asked him when you approached him?
No, I don't.
Okay. Judge, I have no further questions.
Any redirect?
Yes, just briefly. Officer, is it illegal to carry a concealed weapon without a permit?
Yes, it is.
And did you see a gun on this person?
Yes, it is.
And was there a step?
No.
You said that you were in the area. Can you tell us why you were in the area again?
We were doing enforcement control with the ATF.
And ATF. Okay, and this particular suspect, why were you speaking with him specifically?
Wasn't him specifically, it was the 10th precinct specifically.
Okay, and so what happened there? How did that evolve?
What do you mean?
So you were working with ATF.
Yes.
And so how did it evolve that you approached Mr. Copeland?
So on that day, we were in marked police cars and we had undercover officers in the area due to increased violence in the area and shootings in the 10th precinct.
And then, so what happened then?
And then we had an undercover officer who was mentioned in the report. He advised that he witnessed the male walking down the street, and he also confirmed that it was a handgun in his pocket.
Okay, and so when you first approached in the vehicle,
Yes,
you said you see a bulge,
yes, ma'am.
and you said it was L-shaped like a gun.
Yes.
Are there L-shaped phones to your knowledge?
Not that I'm aware of. No.
Yeah. And when you approached the gun, when we saw on the video, could you see the butt of the gun?
Yes.
Okay. And at that time, did you have reason to approach him then?
Yes.
And when you did speak with him, did he offer that he had a gun on him?
Yes, he stated that it was in his pocket.
No further questions, Your Honor.
Ms. Yaldo?
Judge, if I can just have a moment, I'm just passing through security.
Okay.
So I'm sorry. I'm sorry about that, Judge. I have no further questions.
The witness stand.
Thank you.
No further witnesses for the prosecution.
Ms. Yaldo, any witnesses?
No witnesses on behalf of the defense, Your Honor.
Your Honor, the people would ask for a bind over on the single count of carrying concealed.
Madam Defense?
Judge, I would obviously object to the bind over. We all have the right to be free from unreasonable search and seizure when we're walking down the street in broad daylight. My client was a young black male literally walking down the street in the middle of the afternoon. It's 2:40 in the afternoon. All he's doing is walking down the street with a bulge in his pocket. It could be a cell phone. It could be a wallet. It could be an inhaler. An inhaler has an L shape. The officer testified that she did not see anything in my client's possession in plain sight that was illegal. He was not engaging in any sort of illegal activity. He was not engaging in any sort of suspicious behavior. He was literally doing nothing but walking down the street in broad daylight. And again, Judge, under the Fourth Amendment, we all have the right to be free from unreasonable search and seizure. The standard here, if at all, would be a Terry stop. If the officer had reasonable suspicion to believe that my client was engaged in some sort of suspicious or illegal activity, they can stop for the purpose of questioning, and then from there develop their investigation. But to simply see a bulge from a distance and immediately seize my client and search him, Judge, that is a clear violation of the Fourth Amendment. So I am asking that, I'm objecting to the bind over, and I'm asking, Judge, that you dismiss these charges in their entirety. Thank you.
Prosecution?
Thank you, Your Honor. With the information from the informant of the task team, the ATF FIT task team, as well as the bulge that the witness did identify, and with the butt of the pistols clearly sticking out in the video, Your Honor, the people said that there was definite reasonable suspicion to approach Mr. Copeland, who then admitted he had the weapon and he does not have a CPL. We would ask for a bind over on this matter.
Thank you. Having the testimony that was provided by the prosecution here.
I'm on Zoom.
Can you mute your microphone, please? After having heard the testimony that's been provided here by the prosecution, the question is whether or not the prosecution has cleared the hurdle of probable cause to believe that crimes were committed in the city of Detroit, County of Wayne, and probable cause to believe that Mr. Copeland, you were the person that probably committed that crime. And with the testimony that has been elicited here, that the officer had followed up on information that she received from another officer, was given a description and was given what the concern was, that officer responded along with her partner, and upon seeing an individual matching that description, that being the defendant, who she clearly identified here today in court, Mr. Copeland being in the Zoom gallery, the officer then indicated that she observed her partner approach, and there was some discussion, and that she heard the defendant say, "It's in my pocket." She indicated what she saw, the description that she gave to the court here in the record is that she saw what a bulge, which in her training and experience, she believed was a firearm. And she was very emphatic about it on the record, as the transcript will certainly confirm. And subsequent to that, her partner did remove a firearm, a Smith & Wesson 9mm black firearm from the defendant's pocket. She also confirmed that there was no CPO and that firearm was placed on evidence, and provided the evidence tag number as well. Probable cause has been met here. So this is just so that Mr. Copeland, so that you understand what this process is here today. This is not a trial. This is an opportunity for the prosecution to present evidence. The standard is probable cause, sufficient for this matter to move forward. The prosecution has done so. So I am going to bind this matter over to the district court for further proceedings with an AOI date of August 23rd.
Am I able to say anything at all?
Madam Defense, did you want to go in a breakout room with him, or I don't want him to say something that might?
No, Judge. Thank you. Mr. Copeland, just hang tight. We'll talk. There's not much you can say right now that's going to change anything. So just hang tight. We'll talk as soon as this is wrapped up, okay?
Okay.
Was there anything further you wish to address?
Not on behalf of the defense, Your Honor.
Not on behalf of the people, Your Honor.
Thank you.
Thank you.
Thank you. Thank you, everyone. Good morning, Mr. Brown.
Good morning, Your Honor.
Your Honor, Larry.
Yes, ma'am.
Calling parties on Larry, case number 2156230. The people of the state of Michigan versus Vanessa Larry. The defendant is charged with count 1, assault with a dangerous weapon, felonious assault. This is scheduled for a preliminary exam.
Thank you. Appearances, please.
I think Rima.
Oh, sweet stuff.
Yeah, I'll see if I can find her.
Yeah, I thought it was yours, Mr.
I have Wadsworth, but you probably,
Well, they had.
I'll see if I can find her. She's not on the call, so she'll step away for a second. If we want Wadsworth, we'll be quick though, if we want to call that.
All right.
Calling
Parties on Wadsworth, case number 1958442. The people of the state of Michigan versus Jareel Wadsworth. Sorry, I didn't realize he was here. People of the state of Michigan versus Jareel Wadsworth. The defendant is charged with count 1, assault with intent to do great bodily harm, less than murder or by strangulation. Count 2, domestic violence aggravated. This is scheduled for a preliminary exam.
Thank you. Appearances, please.
Jacob Bloomers on behalf of the people.
Good morning, Your Honor. Daniel Batar on behalf of Mr. Wadsworth, P62191.
Okay, and your client?
Mr. Wadsworth, say your name for the record, please. Jareel Wadsworth.
Thank you. Today is the date and time set for a preliminary examination in this matter. Are we proceeding to an exam?
Your Honor, at this time, the complaining witness, Raya Al-Haq, is not present in the courthouse. Was free to be here for an 11 a.m. preliminary exam. Without her presence and participation, the people are unable to go forward as we count 1.
Is there a motion?
Move to dismiss, Your Honor.
With that being said, I am going to grant that motion to dismiss as it relates to count one, the felony. Matters dismissed without prejudice. Please keep in mind that it is possible that the matter can be reissued. If that is something that catches you off guard, please make sure you speak to your attorney about how and why and the parameters of that. You understand what I'm saying? Can you hear me? Okay, so when a matter is dismissed without prejudice, it's dismissed. But the prosecution has the discretion on whether or not to reissue. If they follow up and gain information as to why perhaps the complaining witness wasn't here, etc., they can reissue. Most people don't understand that when they walk out of the courtroom. All they hear is the word dismissal, and they don't understand that. I like to explain it, so that in the off chance it does get reissued, you're not caught off guard. Can you unfold your arm, sir? Thank you. So with that being said, count one is dismissed, again, without prejudice. Count two is going to be set for a pretrial before the corresponding judge, which is Judge Garrett, I believe, on August, what date? 16th.
Count two was the misdemeanor, aggravated domestic violence.
Say again.
August 16th.
August 16th
At 9 a.m.
at 9 a.m. before Judge Garrett. And I just need, counsel, I need your signature on the dismissal of the felony. I'm going to hand it up to you in just a moment.
Judge, and I would just like to know for the record, for that pretrial that's coming up on August 16th, I will not be representing Mr. Wadsworth going forward. I am not on the 36th District Court appointed list, so we will have new counsel appointed at that time.
Yes, Misdemeanor Defender's Office, I believe, is present, and they do handle anyone that needs representation.
Thank you.
Is that correct?
That's correct.
Well, that's the only reason I said that. Mr. Wadsworth, I'll talk to you in a moment.
We can discuss that,
Charlie. Thank you, Tim. Thank you, Judge. Have a good day.
You too, take care. We ready on this matter? It's a recall of People versus Vanessa Larry. This is 2156230. This case was already. Can I have appearances, please?
Good morning, Your Honor. Rima Cookie on behalf of the people.
And good morning, Your Honor. Brian Brown, P80560, appearing on behalf of Ms. Vanessa Larry, who's present. Ms. Larry, please state your name for the record.
Vanessa Larry.
Thank you. Today's the date and time set for preliminary examination. Are we proceeding to an exam today?
Your Honor, at this time, the people are not ready to proceed. Complaining witness Katrina S. Norman has not showed up to the courthouse today.
Have we received any phone call from that individual?
No, no calls.
All right, is there a motion?
Yes, Your Honor, we would motion to dismiss, please.
It's currently 11:10 by the court's clock, and this matter was set for a preliminary examination of 11 a.m. That being said, I am going to grant that motion to dismiss. The matter is hereby dismissed without prejudice. Keep in mind that trailer language after the word dismissal, without prejudice, that means that it is possible that the prosecution can reissue. If you have questions about that concept, please make sure that you speak to your attorney so that you understand the fullness of that concept. Do you have on a GPS tether that needs to be removed?
Yes.
Okay, I am going to include that language on the order of dismissal, for which I will need, Ms. Brown, I will need your signature after I've prepared this. We will notify the tether unit from our angle about the removal of the tether, but please make sure you have your own copy of this form so that there's no questions about whether it should be removed or not when you go to the tether unit, okay?
Yes, ma'am.
Is there anything further?
Nothing from the defense, Your Honor. Thank you.
Nothing from the people, Your Honor.
All right, you have a seat in the hallway, thank you.
He's got to sign. He's got to sign. Yeah.
You're in chamber.
We have a bunch of things. You can transfer it.
Sure.
You can just change the judge and see that same thing, you just hold it and Archer staff. I got it. We got it too. I have no idea who it came from. Yeah, I got a copy of it too. I don't know who that person is and why they didn't read all the stuff, but we'll figure it out. Yeah, you can just transfer it to us, because we have 2 or 3 of these other cases. Okay, all right. Calling parties on Chambers, case number 2058076, the people of the state of Michigan versus Dante Terrell Chambers. The defendant is charged with count 1, assault with a dangerous weapon, felonious assault, count 2, domestic violence. This is scheduled for a preliminary exam.
Thank you. Appearances, please.
Good morning, Your Honor. Remind me on behalf of the people.
Good morning, Your Honor. Christina Joseph, appearing with and on behalf of Dante Chambers, who is present in the courtroom today.
Okay, please state your name.
Dante Chambers.
Thank you. Today's examination in this matter was set for 11 a.m. It is currently 11:12 in the morning. Are we proceeding to an examination?
Your Honor, at this time, the people are not ready to proceed. The complaining witness in this case, Tommy Pratt, has been subpoenaed and notified to show up to court today and has not done so.
Is there a motion?
Yes, Judge, at this time, the defense would be moving to dismiss this matter. It was scheduled for 11 a.m. It does appear notice was sent to the complaining witness and he has failed to appear. Given that the people are unable to proceed, we would be moving to dismiss.
Okay. Have we received any phone calls from that witness?
No, no calls.
That being said, I am going to grant that motion to dismiss this matter. It's dismissed without prejudice. And what that means, that language after the word dismissal, without prejudice, that means that it's possible that the prosecution can reissue. We know that the defendant, we know that the complaining witness is not here, but we don't know if there's some reason that might explain why the complaining witness is not here. So for that reason, prosecution does have it within their discretion to reissue if they believe that it's appropriate. So please make sure you speak with your attorney if you have questions about that concept of a possible reissuance. Do you have on a GPS tether?
No.
Okay, I just need your signature, counsel, on this order of dismissal as the moving party. And sir, you can have a seat in the hallway. We'll bring your copy out to you.
Thank you.
You're welcome.
Thank you, Your Honor.
What do you want to go next? Okay. No. I have to step out.
Oh, sorry.
Yeah, that's okay. All right, you can have them, take some from you. Thank you so much. Have a good day. You too.
You too. Good to see you, Judge. Good to see you too in person.
Yes, it was nice.
I don't know where all this came from. Isn't that weird? It's like it's very well.
It's a very big research, like, paper on for dismissals both of these. And then it looks like Mr.
What's going on with Mr. Haitian's matter?
I think it's gonna be a whole, and then that'll be all we have until the.
Good morning, council.
Morning, Judge. How are you?
Good, how are you doing?
I'm good. Good morning, Miss Tammy.
Good morning.
I'm checking in on Fulton.
Yeah, I got you. I'm having the officer see if he's in the hallway.
Okay.
Are there witnesses on that? No. Yeah, I don't believe there are any witnesses on Fulton, but I'm not sure if he's here.
Probably not. Mr. McRipley had not heard from him.
Oh, what's name? Bloomers. Jacob Bloomers. The last one?
Is Mr. Bugs here?
No,
No, Mr. Fulton? No, Fulton.
Okay.
Oh, yeah, that's not.
We're gonna go ahead and call it. Calling parties on Fulton, case number 2059184. The people of the state of Michigan versus Marquand Dequez Fulton. The defendant is charged with count 1, weapons carry concealed. This is scheduled for a preliminary exam.
Thank you, ma'am. Appearances, please.
Good morning, Your Honor. Remax on behalf of the people.
And good morning, Rachel Jordan, appearing on behalf of Marquand Fulton, standing in for the attorney of record, Mr. McRipley. Today is the date and time set for a preliminary exam. We have had no contact with Mr. Fulton and do not have an excuse for his absence.
Okay, it's currently 11:28 in the morning. This matter was set for an 11:30 exam. Did you want to wait 2 minutes or, oh, wait, I'm sorry. There's 2 different court clocks. I'm looking at one right in front of me. It says 11:28, but the one on the wall says 11:30. So it is now the time set for an examination. Have we received a phone call from Mr. Fulton?
No, no calls.
And the expectation is absolutely that Mr. Fulton would be here. I understand there are no witnesses, however, but I will not dismiss a matter if the defendant does not join the party, at least by way of Zoom. So is there a motion?
You can move for a habeas, Your Honor.
I am going to grant that motion for habeas as there's been no explanation provided regarding his failure to appear here today. However, if you are able to get in touch with Mr. Fulton before we break for lunch, please Zoom back in with him. And I will allow you to then make the motion to dismiss, as the prosecutor had mentioned off the record that there were no witnesses. But in that instance of him being present, at least by way of Zoom, that habeas again is going to be entered. Previous bond is forfeited. New bond is going to be set at $5,000 cash or surety.
Okay, thank you so much.
You're welcome.
Have a good day.
You too.
Yeah, I got you. Calling parties on Bugs, case number 2062113. The people of the state of Michigan versus Marcus Gerard Bugs. The defendant is charged with count 1 and 2, assault with intent to do great bodily harm less than murder or by strangulation. Count 3, weapons carried concealed. Count 4, controlled substance, possession, cocaine, heroin, or another narcotic less than 25 grams. Count 5, weapons, firearms, possession by felon. Count 6, 7, weapons, felony, firearm. Count 8, weapons, felony, firearm. Habitual offender, third offense notice. This is scheduled for a preliminary exam.
Thank you. Before you put appearances on, what do we do with chambers? Why do I still have this up here? Was that a dismissal?
I just need to file.
Oh.
It wasn't dismissed.
Oh, let me put the note in. Okay, appearances, please.
Jacob Bloomers on behalf of the people.
Arnold Weiner, P 22104, retained counsel on behalf of Mr. Bugs, who was present in court. No objection to proceeding in person, Your Honor. The offense is ready to proceed.
Wait, I'm sorry, hold on one second. Can I see the dismissal form on that one?
On the last one?
Yeah.
Yes, and proceed in person. How do you say that?
I think, let me look.
I'm sorry, I'm separating the two. I do note on that last one, there was a misdemeanor accompanying. But Miss Young would be, it's not in here right now, so.
Oh,
Wait, I feel
No.
like we
did give a date to Chambers.
Yes.
for a pretrial.
But the one we just called was Larry, the last one we had was Larry Vanessa Larry.
Can I see that one?
Yeah, we did give a pretrial date to Chambers.
Let me see the dismissal again, because I feel like I did not write count one only on that.
Okay. And I'll send her a new copy too.
And the pretrial date is August 16th?
Yes.
I feel like I wrote that, and maybe it's, I'm not sure if it's in the wrong file.
I'll double check.
All right. On Bugs, I know we just had appearances placed on the record. Did you state your name? If so, could you please state it again?
Marcus Bugs.
Thank you. Today's the date and time set for an in-person examination. Are we proceeding to an exam?
Your Honor, at this time, the subpoenaed witnesses, including the complaining witness Catherine Desiree, are not present in the courthouse. They were subpoenaed to be here for an 11:30 a.m. preliminary exam. Without their presence and participation, the people are unable to go forward as to all counts. I'll just say for the record, there are no misdemeanor counts.
Thank you. Is there a motion?
Motion to dismiss without prejudice, Your Honor.
Okay, I'm going to grant that motion to dismiss made by defense counsel. Matters dismissed without prejudice. And what that means, without prejudice after the word dismissal, is that it is possible that the prosecution can reissue. If you have questions about that concept, please make sure you speak with your attorneys and we'll explain it to you in greater detail. Do you have on a GPS tether that needs to be removed? Okay. Mr. Weiner, I just need your signature on this order of dismissal. That'll be handed, Madam
May
Clerk.
I
will-
approach, Your Honor?
Yes, Madam Clerk will hand it to you. And you'll get your copy brought to you in the hallway. Okay, you can have a seat in the hallway. We're all set here.
Thank you, Judge.
Thank you. Is your work done here, Mr. Bloomers?
I am all set.
All right.
Good afternoon, and I will see you tomorrow.
Yes, sir.
It's a pleasure to meet you, sir. Judge, I have one more story, if you have 10 seconds.
I got, well, Tammy, do I have 10 seconds?
You do.
Yes.
Okay, you,
Judge, can I talk to,
I'll
Mr.
dismiss-
Strong? You're zooming in on Culberson, what do you wanna do?
I'm just gonna request an exam date.
He's out,
He is out, I believe.
just a second. December 9th at 9:30.
That's a good day, Tammy.
Okay, you're all set then.
Okay, 12/9.
And Ms. Shafufi or Miss Bailey is the prosecutor if you still need discovery.
Okay, Miss Bailey.
Yes.
Okay. All right, thank you.
Okay, no problem. All right, are we ready on Dixon?
We need a prosecutor. Mr. Haysha, how you doing, sir?
How are you, Judge?
How's it?
It's good. No surgery for the fall. That's
Oh, good.
So it's a relief. And she'll be out of that little cast and into a walking boot, I think, within a week. So
Oh,
thanks for that.
that is
validation this
great.
morning.
Yeah, absolutely.
They're little quick healers.
Mhm.
They do stuff.
Wow.
They get on the mend quickly too.
Who's the corresponding prosecutor?
I think it's Ms. Shafufi.
Prosecutor's not our leader.
Thank you.
You're welcome.
And then this should be it. for the docket. Yeah, I remember you at the afternoon. Calling parties on Dixon. Case number 2061402, the people of the state of Michigan versus Jaquan Dixon. The defendant is charged with count 1 and 2 weapons, firearms, possession by felon. Count 3 weapons, ammunition, possession by felon. Count 4 weapons carried concealed. Count 5 controlled substance, possession, cocaine, heroin, or another narcotic less than 25 grams. Count 6 and 7 weapons, felony, firearm. Count 8 and 9 weapons, felony, firearm. Habitual offender, second offense notice. This is scheduled for preliminary exam.
Thank you. Appearances, please.
Good morning, Your Honor. Remind me on behalf of the people.
And Your Honor, good morning to you, Madam Prosecutor, and court reporter, and the staff. Vincent Haysha, P76506, appearing with and on behalf of Mr. Jaquan Dixon, who's present to my far right in the court.
Could you please state your name? Thank you. Okay. Are there any preliminary matters that we need to take up before we commence with the exam?
Yes, Your Honor. At this time, I believe defense counsel will stipulate to a certified prior conviction that the defendant was convicted of a specified felony and as of today's date has not restored his rights to carry, or possess a firearm.
I would so stipulate there, but
Okay. I make a notation of that stipulation. And anything else?
just a mutual sequestration order, Your Honor.
Sequestration will be granted.
With the exception of the officer in charge.
Okay, you have one here?
Yes.
All right. Is there any objection to that?
No objection, yes.
All right, so the officer in charge will be permitted to be inside of the courtroom. I will state that the courtroom is already restricted due to pandemic protocols that the court is still following. So the only people in here are those that are working in this courtroom and those involved with this case directly. The Zoom gallery, I'm restricting it right now. I've enabled the waiting room, and there's no one in the Zoom gallery other than, again, those working the courtroom. If you hear someone chime in, it will be because I've let them in and it's an attorney. The third tier to sequestration is that we are live streaming on YouTube. So if there's anyone watching the live stream that shouldn't be watching because you're either a witness or a potential witness, now would be the time to stop from watching to maintain the integrity of this process. That being said, is there anything further?
One more thing, Your Honor. If people move to admit people's proposed exhibit 1, it is the lab results for the oxygen gun.
No objection for exam purposes only.
Okay, that will be admitted then, people's exhibit number 1. And for the record, you have shared that with counsel?
Yes, I have, Your Honor.
And I've seen it, Your Honor. I don't have a physical copy, but I've seen it and understand it.
Okay, all right, thank you so much. Anything further?
People call Officer Carry-On.
Could you also state your name, officer in charge?
Officer Brian Anthony Johnson, badge 5010.
Thank you. Could you please state your full name and spell your first and last name for Madam Court Reporter?
Corporal Anthony Carrion, ANTHONYCARRION.
Thank you. Please raise your right hand. Do you solemnly swear or affirm testimony you're going to give is the truth, the whole truth, and nothing but the truth?
Yes.
Thank you, sir. You were just here, so I know you know the drill.
Yeah, I remember.
Mr. Weiner, is everything set? Officer, did he need us for something?
He couldn't find his planner again.
Oh, okay, all right. Madam Prosecutor, once he's settled, you may proceed.
Thank you, Your Honor. Good afternoon, Officer Carry-On. Are you employed?
Yes,
Where are you employed?
Detroit Police Department.
And how long have you been employed there?
Approximately 6 years.
Were you working on October 21st of 2020?
Yes,
Did your duties as a police officer take you to the location of Florence and Schaefer?
yes,
Is that in the city of Detroit County, Wayne?
yes,
And did anything happen on that day that brings us to court today?
yes.
What happened?
We attempted to perform a traffic stop on a vehicle, fled from us, and crashed into a pole.
And when you saw this vehicle, can you describe it?
It was a Dodge Charger, had an improper plate that was stolen, came back to a completely different vehicle.
And when you saw the vehicle, you said that it crashed into a pole?
Yes.
And what did you do after that? After you saw that?
We're about a block back, I observed the vehicle, I observed the driver exit the vehicle.
And when you saw the person exit the vehicle, what were they wearing?
It was a tan jacket, kind of like a Carhartt.
And after he exited the vehicle, what did you do?
We sped towards the vehicle, and I exited the vehicle and got out to search for the man.
And where was the man at this point?
Bystanders advised me he ran behind the apartments northbound.
So you were after him? You were running after him?
Yes.
And after you received this information on where he could be, what did you do?
I continued to travel northbound behind the apartments until I got to the end where there was a fence, and I looked to the right in a little doorway, and I observed the male with the tan jacket laying next to him on the floor.
And when you saw the man there, did you approach him? Did you talk to him?
Wait, I'm sorry. One moment, please.
Okay, no problem. I'll be looking for it. Okay. Well, Who's that? Oh, it is scheduled for the judge right now. Oh, that's okay, no problem.
There's Judge Law over there. He's nice too. He's nice. Yeah. Everybody gets both sides.
Yeah.
What's he? Excuse me, Judge, I'm in the courtroom long enough, I don't remember to stand up.
Oh, no worries, Mr. Hayes. I'm so sorry.
It's okay. Okay. So I think we left off where you said, you found this individual with a coat next to him on the ground?
Correct.
Okay. And what happened after you saw this individual there?
I approached him, ordered his hands up, and he put his hands up, I detained him, and I recovered the coat next to him.
And what did you do
Wait,
after
I'm
that?
sorry, you recovered what?
The coat that was laying next to him, the tan coat.
Okay.
Was it the same tan coat he was wearing when you saw this individual running out of the car?
I believe so.
And what did you do after you detained him?
I walked him back to our vehicle, secured him, and then I went to his vehicle to conduct a search on the vehicle.
Did you conduct the search?
Yes.
What, if anything, did you find?
I recovered a AR pistol from the passenger seat floorboard of the vehicle.
And what did you do when you found this pistol?
I recovered the pistol, made it safe, and placed it in my trunk to be later replaced on evidence.
And I'm sorry, could I trouble you to repeat where you found the firearm? I do apologize.
Yes, it was from the passenger side floorboard of the vehicle.
Thank you.
And you placed it on evidence?
Yes.
And do you remember what the evidence tag number was that you placed it on?
I believe it's notated in the evidence tabs on the report.
was looking at your report, help refresh your recollection.
Yes.
May I wrote?
Yes.
Sign up.
And what was the evidence tag number?
643-331-1.
And what, if anything, did you do after that?
We, like I said, we covered the gun, put in the trunk, and then after that, we conveyed him to Detroit Detention.
Do you see that person in court today?
Yes.
Can you please point to him and describe something he's wearing?
It's like a tan long sleeve.
You want to make the record reflect that the defendant has been identified?
The record will so reflect.
Nothing further, Your Honor.
Cross-examination.
Thank you, Your Honor. Judge, may I do cross-examination from the defense table, or do I need to be at this podium? Will the mic pick up on both?
No, but do you have a special reason? Is there some?
Well, yeah, I'm gonna move this mic just so that I can have, I'm steering a Discovery electronically, so.
Oh, okay.
Okay. Officer, carry on.
Well, I will say this, your voice does carry very well, Mr. Haysha, so if you would be more comfortable doing it there, you can do it there.
I'll try here. If it becomes a problem, I'll see about moving there. But thank you for that, Your Honor. Officer, carry on. I'm gonna ask you a series of questions. If you don't understand what I'm asking, ask me to rephrase. I have a habit to talk quickly. I apologize to the court reporter in advance. But if I start speaking too quickly, just go ahead and ask me to slow down. Fair enough?
Yes, sir.
Okay, great. So directing your attention to this particular date and time, were you the driver or the passenger of your squad car?
Passenger.
Okay, so you had seen this vehicle more than once, correct?
Correct.
Okay, I believe you indicated that there was a some type of some activity some 20 minutes prior. Is that correct?
We observed the vehicle.
Okay, and did you in fact have time to stop the vehicle prior, or were you just monitoring the vehicle prior?
No, we just observed it drive by.
Okay, so you had observed the vehicle 20 minutes prior to this incident, correct?
Correct.
Did not put flashers on, did not attempt to stop this vehicle at that time, correct?
We were on another investigation, so we couldn't.
Okay, so was there anything in particular 20 minutes prior that stuck out to you about this particular vehicle such that you wanted to continue to investigate it?
It had tinted windows, there's no tinted plate in my mind, and
Okay.
ran later on.
So the only thing that was suspicious about the vehicle when you initially saw the vehicle was that there was tinted windows on it, correct?
Sure.
Okay, so when you happened to see this vehicle again, was there any particular reason why you continued to investigate the vehicle?
Because afterwards I ran the plate and it came back to a completely different vehicle that was stolen.
Okay, and when you say you ran the plate, what was the mechanism of doing that?
Via our lean law enforcement information network.
So you punched the vehicle plate into lean, that vehicle came back to being a different vehicle, and you decided to investigate further, correct?
I'm sorry, I didn't hear that.
You decided to investigate further based on running the license plate?
Yes.
Okay, now, at that time that you decided to investigate, were you able to discern how many people were inside of that vehicle?
I believe it was two.
Two individuals inside of the vehicle, correct? Okay, and there was tint in that vehicle, correct?
Correct.
Okay, so there was no way for you at that time initially to discern who was driving the vehicle or who was in the passenger seat of the vehicle at that time, correct?
Well, we passed it going head on, so
Okay.
I could see through the windshield.
Okay, and so you were able to get a description of both suspects pretty clearly by seeing through the windshield at that time, correct?
No.
Okay, were you able to determine whether or not they were male or female?
Not through the windshield.
I'm sorry?
Not through the windshield.
Okay, but you just identified that there were two entities, two individuals that were driving inside of that vehicle, correct?
Yeah.
Okay, did you relay that back to dispatch?
Not at the time.
Okay, when was it that you decided to start contacting dispatch?
I don't recall.
Okay, was it you that contacted dispatch or was that your partner?
It was my partner.
Okay, so your job at that point was to run the vehicle plate on lean, correct?
I had already done that prior.
Okay, and essentially just to assist your partner in whatever mechanisms or action was needed at that point, correct?
Could you rephrase the question?
I'll move on.
Okay.
In terms of the vehicle itself, when you caught the vehicle a second time, or you spotted the vehicle a second time, did you give chase to that vehicle?
No.
Okay. So when that vehicle, you eventually came upon that vehicle, correct?
Yes.
Okay. And was that vehicle in driving condition at that time? Okay. So is it your testimony that you weren't chasing that vehicle? You and your partner were not chasing that vehicle at that time?
Yes.
Okay. When you came upon that vehicle, was it you or your partner that called the dispatch to say that you had spotted the vehicle?
I believe it was my partner, but I don't recall.
Okay. What was the first thing that you noticed about that vehicle in terms of its drivability?
I observed that it hit a pole.
Okay. Was it a pole or was it a fire hydrant?
Could be a fire hydrant.
You don't recall specifically?
Not specifically what it did.
Okay. And did you see both the driver and the passenger exit the vehicle at that time?
I only had eyes on the driver's side of the vehicle, so I saw who was exiting the driver's side.
And you said you were approximately a block away from the vehicle at that time?
Yes.
Okay, and were there other vehicles that were impeding your vision?
No.
Okay, did you have clear sight on the vehicle at that time?
Yes.
Okay, but because your eyes were solely fixated on the driver, the only thing that you're able to remember or to discern from that was that you saw an individual exit the driver's side?
Yes.
Okay, no idea what happened with the passengers of that vehicle, correct?
Correct.
Okay, were you relaying this information to dispatch at the time?
I don't recall if I was.
Okay, now, obviously, you are equipped with department body camera, correct?
Yes.
Okay, and do you remember if that vehicle, that squad car, was equipped with an in-car video?
Yes.
Okay, and was it equipped with an in-car video?
Yes.
Okay, and was that functional?
Yes.
Okay, and did you check to see if that was functional before you drove off that day?
I believe so.
Okay. And you wouldn't dispute any findings within that vehicle, correct?
Correct.
Okay. Now, in terms of what you see and what you do after you notice that this driver exits the vehicle, what is the first thing that you do?
I'm sorry, can you ask that again?
What is the first thing you do after you see the driver of this vehicle exit?
Well, my partner drove the vehicle closer, and I got out and attempted to find it.
Okay. Now, you did not call out to dispatch immediately, did you?
I don't believe so.
Okay. But at some point you did?
I believe my partner did.
Okay. And had you called out to dispatch, would you have been able to give a description at that point of the occupant from that vehicle?
Yes.
Okay. And you're certain that you saw that driver come out of that vehicle in a tan coat?
Yes.
All right. Now, you gave chase, and was it you that eventually went back into the vehicle, or was it your partner that went back into the vehicle? You were the police vehicle, because one of you stayed and one of you went back and got into the police car. Is that correct?
I gave chase to the driver.
Okay. All right. Now, I think you testified on direct that as you were giving chase, you spoke to some bystanders that were able to point out the direction. Is that correct?
Yes.
Okay. Did you get names of those individuals?
No.
Okay. Obviously, that's happening relatively quickly, so you weren't able to go and write down their information.
Sure.
Did you attempt to find them afterwards?
I did not.
Okay. And were you able to identify the direction of that particular individual just yourself, or did you rely solely on the bystanders?
It was a little bit of both.
Okay, so let me ask you this. Without the bystanders, would you have had any way of knowing exactly where this individual had gone?
Exactly.
No. And are you, at this time, aware that the bystanders mentioned anything? I'm not going to ask you specifically to testify to what they said, but did the bystanders, as far as you recall, point out any identifying characteristics of an individual that may have been running at that time?
I don't recall.
Okay, so you don't recall specifically any bystander saying, I saw a guy in a tan jacket running this direction, correct?
No, I saw him prior to it.
Okay, you saw someone running in a tan jacket, correct?
Yes.
Okay, were you able to identify a facial feature of the person?
Not from him running, no.
Okay, and so were you able to identify anything other than tan jacket at that time?
No.
Okay, and so you give chase for approximately how long?
Maybe 30 seconds a minute. I don't know.
Okay, and then eventually you come upon an individual that's in an alleyway, correct?
He was in a doorway.
Okay, doorway, but that doorway was, you acknowledge, within an area of an alleyway, correct?
It was behind the apartments.
Okay.
So in between the fence and the apartment.
Okay, so maybe not an alley, but it's certainly a corridor, correct? Okay, and at that time, that individual, was he armed?
Not at that time.
Anybody give you any indication that the person running had tossed or discarded a firearm?
Not that I recall.
Now, this is broad daylight, correct?
Yes.
You've been an officer for how long?
6 years.
Okay. Would you imagine, and I'm going to ask you a somewhat hypothetical, that an individual that had seen someone running with a firearm might say to the cops, he's got a gun?
If it was visible?
Yeah.
If the gun was visible, maybe.
Sure.
I don't know if it was.
Would you agree that if someone discarded a firearm at some point in time, that firearm probably would have been visible?
Could have.
Okay, and you spoke to not one, but multiple people as you were going through and, giving chase in this 30-second time period, correct?
I don't recall the exact number. At least one.
Okay, would you dispute that it might have been two?
Could have.
Okay, but nobody, and you didn't see a gun at any point in time on any particular individual that was running, correct?
I did.
Okay, and as far as you know, there was nobody that was on scene that may have seen this person that said that he had a firearm, correct?
To my knowledge.
Okay, and frankly, no one was on scene that would have said that there was an individual in a tan coat that was running, correct?
I'm sorry?
Nobody, no bystander said that the individual running had a tan coat on. Nobody gave you descriptive terms of the person running, correct?
I don't recall if they did because I'd already seen it. So I already knew what I was looking for.
Okay, so did you actually talk to anyone, or did you just get directions from someone that was a bystander on the
In
street?
my memory, they said directions. He went, behind the apartments.
Okay, got it. And then just to clarify, you never yourself witnessed this person running in the jacket, aside from what you believe you saw about a block before you made that area, correct?
I saw him exit the driver's side door and run from the vehicle.
Okay, but never saw a firearm yourself, correct?
I did not see from that distance, no.
Okay. Now, you eventually, you approach this individual, and you immediately detain him. You have your firearm drawn, you detain him, correct?
Correct.
Does he make any statements to you at that point?
I don't recall.
Does he admit that was my jacket right there?
I don't recall.
Does he say, I just tossed the gun?
Not to my recollection.
He didn't say anything, did he?
I don't recall.
Okay. You arrest him, and eventually, does he cooperate with you at that time?
At that time, yes.
Okay, he's not resisting or doing anything untoward at that time, correct?
Not to my recollection.
Okay, and so you take him back, and you go, you book him, and that's the extent of what you do until you go to the vehicle, correct?
Yes, I placed him in the backseat of a scout car, yes.
Okay, and when you go back into the area where the vehicle had crashed, I'm talking about the charge that it crashed, you do a little bit further investigation, correct?
Yes.
Okay, and it's at that time that you indicate that you find what is, I believe, a AR pistol that's on the floorboard?
Correct.
Okay, and now you saw this particular individual in the tan jacket exit from the driver's side, correct?
Yes.
And it's your testimony that there were two occupants of that vehicle, correct?
That's what I believe I saw.
Okay, you believe you saw someone sitting in the passenger. You may not know who was man, woman, but you saw two people in that vehicle, correct?
Yes.
Okay, and that firearm that's inside of that vehicle, that's in the passenger floorboard area, correct?
Yes.
Okay, was that, just sitting right up, taped to the floorboard, or was that tucked away inside of the floorboard?
It was just sitting on the floorboard.
Okay, passenger side area, correct?
Yes.
Not the driver's side area.
Right.
Okay. Did you, at any point in time, have that AR pistol ran for any prints or any DNA analysis?
After we turned it in for evidence, they may have done that. I'm not sure what happens after.
To your knowledge, was that done?
To my knowledge, I don't know.
Okay, so sitting here today, do you think it's more likely that that firearm was belonging to the driver of the vehicle, or that it could have been the passenger's firearm?
I don't want to speculate.
You don't know?
I don't want to speculate.
You'd say there's no way of knowing that, correct?
I couldn't.
There's no active indicia at this point to let you believe that that was something that belonged to the driver of that vehicle, and you're strike that. That's a terrible question. You'd agree with me that firearm that was recovered could have just as easily belonged to the passenger of that vehicle as it could have had the driver, correct?
I mean, it could have been anybody's.
Okay, very well. But you have no way of knowing independently who that belonged to, because there was no other investigation that turned out facts that supported that it was in the possession of Mr. Dixon at any point in time, correct?
Unless the lab results show different.
Correct, but we don't even know if there are lab results at this point, correct?
I don't.
Okay, got it. So to be clear, On the first go around with this vehicle, which was 20 minutes prior to you seeing this vehicle crash, at no point in time did you go and try and investigate that vehicle or attempt to stop the vehicle, correct?
I was outside of my vehicle on a traffic investigation, so there's no way I could have. I wasn't even out.
Okay. Aside from you running the plates and determining that that vehicle, that the license plate did not match that vehicle, there was no other reason for you to approach that vehicle or to have given chase to these individuals at that time, correct?
The license plate also came back to a stolen vehicle, which made a higher offense.
Okay, but aside from that, you weren't until you ran that plate through lean when you approached that vehicle, which was just at that point, the vehicle that had crashed in the street. There was no reason for you to go and investigate these individuals before you did that when you approached the vehicle after it had crashed. Is that fair?
The front windows were tinted too darkly, so I mean,
So are you saying,
there was other probable cause.
are you saying that it was your intention to stop that vehicle because for the primary offense of window tint?
Not at the time we saw it the second time. No, we already knew that it had a stolen plate of the vehicle.
So maybe I'm just missing something. Did you run that license plate? Did you have that license plate ran in lean after the first encounter with the vehicle?
Yes.
Okay. So, and on that basis, were you then searching for that vehicle?
No, we were patrolling the area.
Okay, so you just happened to note that for no particular reason, and if you saw the vehicle, you would stop, and if you didn't, you would move on and go about your day. Is that your testimony?
That's how I knew the vehicle needed to be stopped.
Okay, but you weren't actively investigating that vehicle after the first encounter,
I
correct?
just happened to be driving, saw it coming towards us.
Okay, very well, just a moment.
Ms. Silver, we're gonna call your case.
Yes, Judge, my client is in the waiting room.
Oh.
If you don't
Your
mind
client-
bringing him, just so he can hear what's happening.
Is, on this case, is
I'm
Ms.
sorry?
Bailey also in here? Are you here on James Jones, right?
Correct.
It's just an adjournment that Brenda asked for last week. Okay. And I asked her to- I'll call it Jones. Calling parties on Jones, case number 2057459. The people of the state of Michigan versus James Dwayne Jones Jr. The defendant is charged with count 1, assault with a dangerous weapon, felonious assault. Count 2, weapons, felony, firearm. Judge, this is scheduled for a preliminary exam on August 4th, and prosecutor Ms. Bailey had asked me to call this so it could be adjourned.
Thank you. Appearances, please.
Good afternoon, Your Honor. Remind me on behalf of the people.
And good morning, Gabby Silver appearing on behalf of Damon James Jones. He's not quite in yet. Normally I would waive his presence, but I think he needs to hear what's happening.
Okay, we'll pass on this. We're gonna finish up this examination. And it looks like he is trying to connect the audio, so we'll give him a few minutes. Mr. Haysha?
Thank you.
We're back on the record in the matter of People versus Dixon, 2006140. Appearances quickly, please.
Remind me on behalf of the people.
And Vincent Haysha on behalf of Mr. Dixon, 76506.
And Mr. Dixon? A little louder. Thank you. Okay, Mr. Haysha, did you have any further questions?
Just last question, I'll just carry on. The first incident that you observed this tinted window, how was it that you were able to recall, if you were on a traffic stop, what the license plate number was? How were you able to discern that?
I was standing on the passenger side of the car. We were finishing up the stop, so my attention wasn't on that vehicle anymore. I saw that vehicle pass, and I looked back at the car, saw the plate.
Okay, so your testimony is you looked back, you took down the information from the plate, you ran the plate, and then subsequently tucked that into your Rolodex of information for future potential investigation, correct?
Sure.
Okay, very well. I don't have any further questions at this time.
Can you redirect? No redirect, Your Honor. Thank you for holding. Any further witnesses for the prosecution?
Yes, the people call Officer Wakey.
please state your full name and spell your first and last name?
Yep, Officer Wakey, Detroit Police Department, badge 4635. My first name is spelled Henry. Henry.
I'm sorry, did you spell your last name?
Wakey, W-A-K-I-E.
Thank you. Please raise your right hand. Do you solemnly swear or affirm testimony you're going to give is the truth, the whole truth, and nothing but the truth?
I do.
Thank you, sir. You may have a seat. This half gate will swing open towards you. Please watch your step. Once please settle, you may proceed, Madam Prosecutor.
Thank you, Your Honor. Good afternoon, Officer Wakey.
Good afternoon.
Are you employed?
I am.
With who?
City of Detroit,
How long you been employed there?
5 years.
And what is your title?
Police officer.
And were you working as a police officer on October 21st of 2020?
I was.
And did your duties as a police officer take you to the location of Florence and Schaefer?
It did.
And is that a City of Detroit County Wayne?
It is.
And did anything happen on that day that brings this to court today?
Yes, we attempted to conduct a traffic stop. We found that the vehicle had taken off and crashed. And,
I'm gonna stop you right there. When you say we, who are you referring to?
my partner and I,
And what's your partner's name?
Officer Anthony Carrion.
And, okay, so what happened when what did you see? I'm sorry, can you repeat what you saw?
Yes, we observed a vehicle with dark tints. We went to turn around to attempt a traffic stop. The vehicle took off at a high rate of speed. We went to initiate. By the time that we had even made our corner, the vehicle had crashed up in the area of Florence and Schaefer.
And when the vehicle crashed, what did you do?
We had one get out on foot and.
If you could make sure, I know you were working with Officer Carrion, but if you could make sure that you can find your answers to the singular.
Sure.
Thank you.
Yes, I observed someone fleeing through the alley.
And what part did you see him flee out of?
The vehicle you said?
Yes.
The vehicle,
What
the
part?
same vehicle that we had turned on, I believe it was a Dodge Charger, if I remember correctly.
And what part of the vehicle did you see this person flee out of?
By the time I saw him, I can't say for sure, but I believe he was the driver. It looked like he was cutting in front from that direction.
Do you remember what this person was wearing?
I remember a Carhartt jacket.
I'm sorry?
I believe it was a Carhartt work jacket.
Do you know what color that is?
I have to check my report to be 100% certain if I dictated it there.
Would looking at your report refresh your recollection?
It would.
May I approach your honor?
Yes, he was wearing a tan Carhartt jacket.
Thank you. And when you saw this person get out of the driver's side of the vehicle, you saw him running?
That's correct.
And what did you do after that?
I stood by with the vehicle.
The vehicle that this
Had
person got
crashed
out of?
and ran, yes.
And what did you do at this vehicle?
I stood by as my partner gave chase, called for assistance.
And is that Officer Carrion?
That's correct.
And after he gave chase and you stood by the vehicle, did you do any further investigation?
I did. We did investigate the contents of the vehicle.
And what did you find in there, if anything?
There was a backpack containing narcotics.
Where was the backpack?
I don't recall if it was in the front or the back seat, but I know it was inside the vehicle.
And when you saw the narcotics, what did you do?
There was a few items of marijuana, and then there was also a pill bottle that contained miscellaneous pills. I called poison control, spoke to a officer or agent there, gave them the description of the pills. They notified me that it would be oxycodone and it would be a Schedule II narcotic.
And usually when you find narcotics, is there some form that you fill out?
Once we process the evidence, yes, we do a lab request form to determine if the substance is in fact a scheduled narcotic.
And do you remember doing that?
I did.
And do you remember what the incident number is?
It would be the report number. I don't know if are you referring to the incident or the lock seal?
the incident number.
I would have to check the report, I don't know.
And, well, would that incident number match the incident number on the report?
That's correct.
Would looking at your report help refresh your recollection?
It would.
May I approach you?
Yes.
Thank you. So the incident number for both the report and what is here on our laboratory request is going to be 2010210277.
And after you obtained this incident number, did you submit these for testing?
We do the request and the narcotics unit will be the ones who send it out. I don't personally send them.
And, but to your knowledge, do you know if it was sent out?
Yes.
Your Honor, at this time, people move to admit People's Proposed Exhibit 1.
And there was no objection. I believe it was already admitted.
And tries to publish before them.
Oh, yes. Any further questions for this officer?
Nothing further for this witness, Your Honor.
Cross-examination?
Officer, could you pronounce your last name for me?
Wakey?
I don't wanna demote you. Is it officer, is it sergeant?
No, just officer.
Okay. And Wakey, you said?
That's correct.
Okay, Officer Wakey. I have a tendency to talk quickly. If I do so, ask me to slow down. If you don't understand what I'm asking, can you ask me to rephrase, please?
Not a problem.
Perfect. Okay, so I want to break this down just into basically two subsections. The first subsection is the first time you saw this vehicle, the second will be the second time you saw this vehicle. Can you follow that?
I can.
Okay. So the first time that you or your partner noticed this vehicle was when?
I believe we were at Puritan and Schaefer.
Okay, and you were conducting a traffic stop at that time, correct?
Not initially, no. We had observed the vehicle at first. It had caught our attention due to the illegal tint. So we were going to investigate further. We,
Yeah, you can make sure you respond in the same.
sorry, I know that we turned around there, or I turned around there, because I witnessed the illegal tint. At which point the vehicle had turned northbound Schaefer and took off at a high rate of speed. I was originally stuck at the light. We initiated our lights and attempted to go and conduct the traffic stop, at which point the vehicle had already fled and the term we would use is cracked up or crashed up by Florence and Schaefer.
Okay, so you were not, just to be clear, you were not, at the time that you first noticed this vehicle, you were not effectuating a separate traffic stop at that time, correct?
I had not initiated a stop at that time, no.
Not as to this vehicle, I'm talking about you weren't already in progress on a separate, unrelated traffic stop at that time, correct?
That I can't say for sure, I don't recall.
Okay, were you in the vehicle when you first noticed this vehicle, in your vehicle?
Was I in my scout car at the time that we observed the vehicle with the tint?
Yes.
That's correct.
Okay, and was your partner in the scout car at that time?
Should have been, yes.
Okay, and as far as you know, again,
go ahead.
Not effectuating a separate incident for a separate individual or entity for a traffic stop, correct?
Yeah, I cannot recall if we were on a stop, if we were at the store getting a bottle of water. I don't recall that part. I just remember observing the vehicle.
Very well. Okay. After you observed that vehicle, it's your testimony that it was your desire to stop this vehicle for an infraction, correct?
I mean, it's, as partners, it's something that we discuss, so I can't say.
I may go a little longer than that if you want to go and then come back to it.
Actually, so I was trying to be discreet with the note. I think this might be a good time to pause. It's 12:23 by the court's clock. We do a hard stop at 12:30. Typically at 12:25 is when if we're in the middle of something, we stop so that we can select a new date. I've got a 1:30 homicide, so that's not going to be.
And I have an exam before Judge King at
Oh,
12:30, so that's perfect.
All right, so, do you want to pull your calendar up?
If I may.
Am I dismissed now?
Could you stay and could you get Officer, no, I don't think we'll need him, since he's already testified.
I
But
don't
if you
need
could
carry
stay
on,
to
yes.
make sure that there's not going to be a furlough conflict.
Okay, I believe there is one other witness outside as well. if you need
Oh.
them.
The third
One
witness,
more.
could you bring that witness in, please? Because we don't want furlough problems. Unfortunately, as you know, Mr. Haysha, it's not gonna be right around the corner,
Sure,
because we are stacked.
that's fine.
I dare say we're probably looking. Well,
Are we in the
maybe-
22?
I'm gonna leave it to Tammy. We're probably looking reasonably like maybe that last week of September, but probably more realistic, October.
That's fine.
Is it all right if I take my phone out from my calendar?
Oh, yes, absolutely.
If we could look to the second week of October, I'm gonna be in France from the end of September until the 10th of October.
Okay.
Hopefully, we'll see.
Well, I can tell you right now that my honeymoon is in October, so.
Oh, congratulations.
Congratulations.
Wow.
What we.
When is it?
We get married on the 17th.
Of October?
Yes.
And so you're not going to be
So we will
available.
be gone for the last 2 weeks of
So we need from
Why don't we
the,
set it for the 17th of October?
That'd be great.
Wait,
we
you said,
do,
That's a Sunday, so.
right.
you'll be back the 10th.
I'll be back the 10th, yes.
Can we do the 12th at 10 a.m.?
I don't see any reason why that.
And then if we start this is gonna be a held in part, so it will.
Officer in the back of the courtroom,
Yes,
do you have any furlough concerns that day?
on October, no, not at all.
The October 10th, what did I say, 12th?
12.
At 10 a.m.
Fine, that's fine for us.
The 12th should be good for me. I believe I am starting my furlough on the 13th.
Oh, okay, but
But-
when you say you believe,
You wanna
No,
take it?
I think we'll be okay with the 12th.
okay, wedding outfit, fittings that
Well, we
day.
have rehearsal dinner on Friday, so I know that's no good, and then, family comes in the 14th, you know.
Okay,
13th, you have to prep to get ready for family to come in.
right, so the 12th
you
is
know.
running in pretty close, but we promise not to take up too much time.
That'll work.
Okay, he says it's a go, and the officer in the back says it's a go. And we don't need officer carry-on? No. Okay. Mr. Haysha, did you need him to be recalled for some reason?
I don't believe so, no,
Okay.
Your Honor.
All right, so October 12th at, Madam Clerk, 10?
10 a.m.
At 10 a.m. Thank you. Officer
Wakey,
Wakey.
wakey, exit.
Yeah, I was gonna say
Forget it
Wakey, but
again.
that's not it, Wakey.
And congratulations,
And
officer.
Thank you, thank you,
congratulations,
thank
that's exciting. Silver. Ms. Silver.
Did he sign back on?
Yeah, I think.
Yes, Judge.
We lose Mr. Jones?
There he is.
Oh, okay.
All right, so
Thank you
I
for your patience.
called this, do you have anything going on with it other than just that email?
No. It's okay.
Miss Silver may know more about it, I don't know.
I know nothing.
Recalling case number 2057459, the people of the state of Michigan versus James Dwayne Jones Jr.
Oh, thank you. All right, can I have a piece of this, please?
Good afternoon, Your Honor. Rima Cook on behalf of the people.
And good morning, Gabby Silver, appearing on behalf of Damon Jones, who's also James Jones. We lost him.
Could you
Okay,
please say?
Jones Jr. and I have bad reception.
Oh, okay. We kind of have heard your name, but certainly I understand the connection problem. So we're here today because it's my understanding the prosecutor had been in contact with perhaps one of her witnesses, and she wants this matter adjourned because of a conflict.
Your Honor, I believe after reading the emails that had just been sent, the complaining witness is out of town due to some emergency, and she won't be available till September because her mother had a heart attack and a stroke, so she left the state. She's in South Carolina.
Oh, I see. Okay, well, so we have it scheduled now for, I think, Madam Clerk, you said next week?
I think this week, Judge, it's Wednesday.
Sorry. So I appreciate the prosecution bringing that to the court's attention in advance. And certainly, Mr. Jones, the court has to make a determination whenever there's a request to adjourn as to whether or not good cause has been shown. And as an officer of the court, I take the representations that have been made here by Madam Prosecutor in conjunction with the notations from her fellow prosecutor with regards to the inavailability of one of the witnesses. So I do find good cause to adjourn this matter. And can you tell me again what date she said after?
She said later in September.
Okay, so can we find an early October date to adjourn this to? The record should reflect Mr. Jones is out on bond.
October 8th at 11:30.
I would ask for either the 5th or the 6th, or the following week, the 12th or 13th.
Let me pick up. Let me go back.
If that works.
To the 5th. Let me see. The 5th at 11:30?
All righty. Is that all right with you, Mr. Jones?
Yes, ma'am. That should be fine. Now, I do have a question. Is it going to be on Zoom? Because I just started a new job, and that's where I'm at right now, and it's working remotely, and I cannot miss any days. But it will be possible for me to log into Zoom.
No, it's going to be in person. Okay, Mr. Jones, you and I can have a discussion about that.
Ms. Silver, is he saying that there's a period of time for which would he want it later? So that he's not in it probationary?
Mr. Jones, would you like it later in October or earlier November?
Well, I'm like I said, I'm here drug testing for the job, and they said I cannot miss the first 90 days. Like, that's why I said it would be possible for me to log in on Zoom, but it'll be hard for me to come in person. But if I do,
Mr. Jones, when is 90 days up?
The start day is actually, I signed in August 30th. That's the soonest they can get me in.
Oh.
Yes,
Well.
ma'am.
Would an afternoon work better for you, maybe?
Yeah, but we won't be getting off about 4 o'clock. But I'll just have to try somehow to make it work. I'll figure it out. I appreciate you guys.
Well, maybe we could do it the very last week of November or first week of December.
Okay, let's look there and give us.
Yes, December probably will be better because it'll be closer to 90 days.
Okay.
A little more understanding.
Right. We're looking up a new date in December.
I appreciate you guys so much. God bless.
Yeah, Mr. Jones, you look very respectful with that, respectable with the haircut and the collared shirt. Good.
Thank you.
I'm sorry, Tammy, what did you say?
December 6th at 9:30.
It's fine.
December
Yes,
6th.
ma'am.
December 6th at 9:30 will be the examination date. Ms. Silver, if there's anything that comes up in the meantime, if you have a concern, you always know how to reach us.
I do. Thanks so much, Judge. Have a great afternoon.
Take care.
Okay, you too, Tammy. Bye, guys.
Okay, we are in recess. Ready? Do you know whether caution and make sure that we have someone that can advise independently the witness. So we will pause in order to get someone to zoom in and speak with the complaining witness. As a side note, can I see both the prosecution and the defense? Yes.
Answering over there.
Okay. We are going to start in the matter.
I don't think I'm still muted. Am I?
Wait, say again?
You know how you had muted me?
Yes.
I can hear it, I'm here. Is that,
Wait, I'm confused.
it's an echo.
This is Judge Archer's.
I don't hear it.
You know when you had muted me at
Yes.
the beginning?
Yes. You
Then
hear the
it's
echo
not
now?
muted anymore.
Do you hear the echo now?
Yeah,
Oh, do you have something in your ear?
no. So do you want me
I
to
don't
go
hear
out
an
and come
echo.
back in right quick?
Sure, maybe my ears just are not catching it. I don't hear that.
I'm not hearing it either.
But yeah, go ahead.
Okay.
I guess I do hear faintly, but it's just not as loud as it
It's like,
typically is. So do you want me to remove you and then you can come back in?
Yeah, I think that's, yeah.
Oh, I thought you were gonna do it.
No, I was going to leave. Okay, I'll start over, Joe. Okay, I'm starting over.
I don't know. That's the first time ever I've ever gotten into this and enter that phone number.
Okay.
Okay, you see me?
Yeah, I do.
And then I'm going to not. So I didn't put one that was highlighted before, so
Well, you don't need audio, right?
no.
Because you're here, so.
It says join with audio, computer audio.
No, so put no.
Okay.
No.
Okay, I just muted you.
Okay.
I think we're gonna be fine now. This
We'll
is-
figure it out tomorrow.
Okay, this is People versus Xavier Atkins. And this is 210-58045. Date and time set for preliminary examination. We're getting ready to proceed with calling the first witness, but let me, as a matter of housekeeping, indicate that I have granted the request for sequestration with an exception for the officer in charge if that person does appear, as well as an exception for the mother of the complaining witness. to be present in the courtroom while the complaining witness is testifying. Otherwise, the courtroom is free, void of any spectators. Only those in the courtroom are those that are involved with this immediate case and those working the courtroom. The second tier to sequestration is that the Zoom gallery is up and running. However, I have restricted it to just people who are working this particular courtroom. And in the event you hear someone chime in, it will be because I've let them in and they're an attorney, likely checking on what's going on in here. The third tier to sequestration is that we're live streaming on YouTube. So if there's anyone watching the live stream that should not be watching it because you're either a witness or a potential witness, now would be the time to stop from watching these proceedings to maintain the integrity of this process, as it may preclude you from testifying in the future if you continue to watch. There was a brief pause in the proceedings for a moment because counsel had expressed a possible concern that the witness might need to consult with their own independent counsel prior to testifying here today. And we have, in response to that, put a call in for a new or for a court-appointed attorney for the complaining witness. We have not heard a response back from that line, that call yet. However, that does generally happen very quickly, that someone zooms in, and then we would arrange an opportunity for the witness to speak to an attorney. That being said, now that I think about it, I'm not so certain. I mean, again, both prosecution and defense, you know, you're far more intimate with this case than I am in terms of the potential pitfalls that might be present with the witness's testimony and the need for a court appointed. I'm not certain if it's a good idea to proceed even with direct examination without that individual having an opportunity to consult with counsel. Again, I have no idea if it's, I always like to err on the side of caution. But again, I'm going to have to defer to the prosecution and defense. If you're both stipulating to proceed with, at the very least, direct examination, then I think that I'm fine with it.
Your Honor, may I speak with the complaining witness for a minute?
Sure.
It's telling me to hold for an operator, but there is no operator. So I'm not sure how quickly we'll be able to get someone or not.
That is unusual. So I think I just want, for housekeeping purposes, Madam Clerk, the CODI is up October 19th.
I believe so.
That was the matter to which Mr. Bazzi had withdrawn and Mr. Blake came in.
Oh, no. Oh, that's right, we just did that. Friday.
So my question of the day is this. I was just watching Women's
Okay.
We've already proceeded, Your Honor.
All right, please call your first witness.
People call Rasheen Andrews.
Good afternoon. Could you please state your name and spell your first and last name, please?
Rasheen Andrews, Rashien.
Thank you. And could you please raise your right hand? Do you solemnly swear or affirm testimony you're going to give is the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you. If you could come over here and that little half gate will open up towards you, and watch your step as you take your seat in the witness chair. Please also make sure you keep your voice up nice and loud, like maybe a little bit louder than you think is appropriate, so that we can hear you, because if you don't, we're gonna have to ask you to repeat everything, and I know that won't be fun to do.
Okay.
Madam Prosecutor, your witness.
Mr. Andrews, I'm gonna ask you to restate your full name for the record.
Rasheen Andrews.
Mr. Andrews, I'm gonna turn your attention back to April 18th of 2021. Do you remember that date?
Yes, I do.
And any time in that day, were you at the location of Michigan near Dover?
Yes.
Is that in the city of Detroit County of Wayne?
Yes, it is.
Did anything happen on that day at approximately 12:55 in the morning that brings us to court today?
Yeah, I got robbed.
Okay, I'm gonna back up a little bit. Where were you at that time?
In the morning, I was on Gilbert in front of my friend's house.
And were you alone or with somebody?
I was with I was alone in my vehicle. My friends were in their vehicle to the left of me.
Okay, and so you were driving that day?
Yeah.
Okay, so
So
tell me,
Yes.
so tell me what happened
From the beginning,
at that time, yes.
at that time, as soon as I pulled up to my friend's car, a car pulled up and blocked my car off and got out with a shotgun and a pistol. It was 3 individuals. And then they ran up to my friend's Malibu. My friend got out, the guy with the shotgun hit my friend.
I'm gonna stop you there for a minute. So you pulled up to a car, next to your friend's car,
Yeah,
and then you said that a car pulled up from behind you,
yeah.
and what did that car do?
It pulled right in front of me and blocked me off.
And then when that happened, did anyone come out of that car?
Yeah, 3 individuals, 1 driver, 2 from the passenger back.
Okay, can you describe these 3 individuals?
One was pretty heavy set, grown man, probably 30s, 35. The other ones was like, they were young, about my age, 20, skinny, about 5'10", 5'12".
Can you describe what if anything stood out to you about what any of these people were wearing?
The driver had a bulletproof vest on, and the other 2, I believe they were wearing black.
Black clothing?
Yeah, like black shirts.
So you said the driver had a bulletproof vest on?
Yeah.
What did the driver do?
The driver, he was pretty much standing there while the guy with the shotgun, he ran up to my boy, hit him. Then the driver eventually grabbed my AR out of my vehicle.
Okay, so were you still sitting in your vehicle when this happened?
No, I got out of my vehicle.
You got out of your vehicle and you said that the driver, was that the person wearing the bulletproof vest?
Yeah,
That person was standing in front of you?
yeah.
And what was he doing?
If you're answering a question that calls for a yes or no, can you, I know in conversation, we typically say yeah, but can you say yes or no so that it's easier for Madam Court Reporter to make a record here?
Yeah, I'll try my best.
Thank you.
The driver was wearing the bulletproof vest?
Yes.
What was that person doing?
He was standing around while the big guy did most of the damage, and then as soon as he saw my AR, he ran into my car and grabbed it.
When you say he saw your AR, where was your AR?
Okay, it was in my backseat.
For the record, I think we all know, but for the record, can you describe what the AR is that you're referring to?
It was a 5.56 NATO. I purchased it that day.
Can
Oh,
you
an
be more
assault rifle?
Thank you.
Okay.
You purchased that assault rifle that day?
Yeah.
Okay.
Yes?
Yes. Sorry.
And were you able to see this person's face, the one that was wearing the bulletproof vest?
Yes.
And do you see that person in the courtroom today?
I believe so.
Was the person wearing a mask that day?
No.
Would it be helpful to you if we all removed our mask briefly for you to see better?
No, it's okay.
What's okay?
Yeah, you can remove your mask for a brief second.
Everyone, for 10 seconds, if you could remove your masks.
Do you see that person in the courtroom today?
Yes, I do.
Can you please just point to him and describe something he's wearing?
He's in that corner wearing the white shirt.
Your Honor, may the record reflect that the defendant's been identified?
The record will reflect identification of the defendant.
Thank you, Your Honor. So where was he standing when you saw him wearing that bulletproof vest?
He was standing in front of my vehicle.
And where were the other two individuals that you talked about earlier? Where were they?
The guy with the shotgun, the big guy, he was standing over my friend, beating him. I think he was stomping him or hitting him with the gun. The guy with the pistol, I didn't really see where he was at because I was mainly focused on the guy with the shotgun.
Okay. So when you saw Mr. Atkins, did you have an encounter with him?
I was telling him like it's a misunderstanding. You guys are doing the wrong thing. Your girl basically tried to run me over in the gas station, and she was just tripping. And they was like, oh, I ain't trying to hear none of that.
And when you say that was a misunderstanding, was that something that happened earlier that day?
It was like cause I was trying to let my girl get inside, and they were just like beep, get out the way. You're not really supposed to pull over inside in front of the road like this. So it was a misunderstanding. I should have pulled over to the side.
So before they pulled up in front of you and did all that, you had your girlfriend in the car with you?
No, I dropped her off.
You had dropped her off, and is that when you first encountered this vehicle?
Yeah.
Okay. So when you told Mr. Atkins that this was just a misunderstanding, what happened?
That's when we saw the AR. He ran, grabbed the AR. I was tussling him for it. Somebody came up behind me and choked me, and then punched the gun in my head and said, "Drop it." So I dropped it.
And where did you grab the AR from?
It was in my backseat.
And then so when he grabbed the AR, you said you were tussling with it?
Yeah, we were tussling for it.
That?
Well, as soon as he grabbed the AR, I grabbed it from him. We were tussling. I'm like, no, you're not about to take my AR. I just bought it today. And then somebody came up behind me, started choking me, and pointed a gun at my head and said, just drop it. So I had dropped it.
And was Mr. Atkins saying anything to you?
No, he was just trying to get the gun out of my hand.
Was he able to get the gun out of your hand?
No, somebody came up behind me and choked me and pointed the gun at my head, so I dropped it.
And after you dropped it, what, if anything, happened? Did anything happen?
Right after I dropped it, they grabbed the gun and ran in their car.
Who grabbed the gun?
I didn't see.
Was it the three individuals that were there?
Yeah, it was the three individuals that were there.
And then they got back into their vehicles?
They got back into their vehicles, drove off, and shot by like 8 shots.
They shot 8 shots?
About that.
Did any of those shots come near you or around you?
Yeah, one hit my windshield and one hit my homie's boat.
Wait, and one hit your homie's what?
His boat, B-O-A-T.
Where was the boat?
It was covering their car.
On whose car?
It was covering the Malibu, my friend's car that I parked next to.
And was this on the street?
Yeah, it was on the street.
And you heard 8 shots?
Yeah.
And what happened after that?
After that, I had to call the police because after that they left. I had to call the police because the gun was registered in my name. So I called the police and then they took it from there.
Nothing further, Your Honor.
Okay, did we receive a phone call back?
I did make a request, just if an attorney zooms in, and that's probably who it is.
Did you? want to proceed, or? you
I think
still
we have to now because he's already talked about something at a gas station, so. So you had purchased this AR assault rifle, correct?
Yeah.
And,
Yes.
and it was loaded, correct?
It was not loaded at the time until they pulled up. When they pulled up, I grabbed my clip from my glove box, tried to rack it up, saw he was already at my friend's car with the shotgun, so I threw it in the back seat.
Okay, so, but nevertheless, before any altercation took place, you loaded up your AR, am I correct?
The clip was loaded inside my glove box. As soon as they pulled up and the situation started happening, I grabbed my AR.
Okay, let me go back and ask that question again. You're driving around with an AR.
Yeah.
You had the ammunition with you in your passenger compartment, correct?
Yes.
And before any tussle or scuffling or anything, you loaded up the AR, correct?
Yes.
And do you know that's it? Do you think you can legally carry around an AR loaded in a vehicle?
It wasn't loaded until I saw them pull up and saw a shotgun. When I saw the shotgun, I grabbed my AR and grabbed the clip, put it inside.
Okay, and you know you were at a gas station earlier, and this is the thing you said was a misunderstanding, correct? You had a misunderstanding, you described it as, correct?
Yeah.
Involving a bunch of young ladies, correct?
Yeah.
You know that sometimes videos are at gas stations, correct?
Yeah.
And isn't it a fact that you displayed or showed some of these young ladies that assault rifle just prior to this incident, is that correct?
No, I did not.
Did you show anybody or tell somebody you had an assault rifle at the gas station? How do you think they knew that you would have had this assault rifle? How do you think they would have known that?
I'm gonna object to speculation.
Objection sustained.
Okay. Well, you said that Mr. Atkins had a body armor on when he came up, correct?
Yeah.
Yes?
Yes.
Okay. And how do you know it was body armor?
It looks like a bulletproof vest.
Okay, so somebody took the time to put on a bulletproof vest just after your altercation, correct?
Yeah.
At the gas station.
The altercation happened at my girlfriend's house and it escalated to the gas station.
But at all these times, at your girlfriend's house, the gas station, and where this incident happened, you had always had the AR with you, am I correct?
Yeah, it was in the back seat.
Okay. And so you, even though it was in the back seat, before the altercation started, you picked up the AR while they were there, right? And loaded it up, am I correct?
Can you repeat that?
While the people that were blocking you, you said, were there, that's when you picked up the ammunition and loaded up the AR. That was your testimony?
Yes.
Okay. And so you have no way of knowing whether they saw you do that or not, am I correct?
Right.
Okay. But you said when at some point, let me take it a little further. Mr. Adkins, you said, was the driver of that vehicle, correct?
Yes.
And when he got out of the car, he didn't have a weapon on him, did he?
No, the other two individuals did.
Okay. And your friends in the other vehicle, are you responsible for what they did?
They didn't do anything.
Wait, say again, can you ask that question again?
Well, you said one of your friends got into a fight.
No, they didn't get into a fight. The guy with the shotgun hit him. He ran up to.
Okay, but
ran straight up to my friend's car and hit him.
Okay, but nevertheless, whatever happened between your friends and the people that drove up, the people in Mr. Atkins' car, had nothing to do with you. Am I correct?
Say that again.
All right, let me ask it a different way. When Mr. Atkins got out of the car, did he have a gun?
No.
Did he demand anything of you?
He really wasn't saying anything.
Okay,
really.
so the answer is no. He didn't demand anything of you.
No.
Did he demand you turn over your gun to him?
No.
Did the tussling start? Is it a fact that you were tussling first, or you said he went for your gun after you said he saw it?
Yeah.
Okay, correct?
Yes.
So, so there was no, before he took the gun from you, or someone took the gun from you, Mr. Atkins didn't demand the gun, and he didn't threaten you in any way, did he?
He was standing there with the other individuals trying to rob me. So yes, I was threatened.
Well, what was he trying to rob you of?
My life, it could have been.
No, not could have been. When you rob somebody, you're trying to take something from them. What was he trying to take from you? What were they demanding? You said it was a robbery. What was he trying to take?
When they pulled up, they wasn't demanding anything.
Right. So there was no, so the purpose of them stopping you was not an armed robbery, correct? It was to talk to you, correct? About this misunderstanding, am I correct?
They didn't want to talk.
Okay.
As soon as they pulled up, the guy with the shotgun ran to my friend's car. As soon as I saw the guy with the shotgun, I grabbed my AR, grabbed my clip. As soon as I saw he was already at my friend's face with the shotgun, I threw my AR in the back seat. They seen it through the windshield. And when I seen the big guy tussling with my friend, I went over there. The big guy ran after me. He was trying to hit me with the gun. I told him, no, I was running back. Like, no, you're not going to hit me with the gun. He pointed the gun at me, told me to get on the ground. I was on the ground. He was pointing the gun over me and told me to pray for my life.
All right, now let me ask you this about Mr. Atkins. Did Mr. Atkins threaten you in any way with a gun or otherwise to take your AR? Did he threaten you?
He didn't say anything, but he did take my AR.
But you said when he saw it, he went and grabbed it, correct?
Yes.
Were you going to grab it?
I threw it back in the back seat, so no, I was not going to grab it.
Oh, okay. And what is it that you said once he tried to grab it, then you tussled with him?
Yeah, I grabbed the top of it. We were tussling for it. I tried to rack it back.
Why were you tussling?
Because he taking my AR.
So you were not in fear?
No.
Because it was yours.
He was taking my AR, so I'm like, I'm not gonna just let him take my AR. So when I grabbed it from him, we were tussling. Somebody came behind me, started choking me up, and pointed the gun at my head. When they pointed the gun at my head, I dropped the AR.
Okay, then you dropped it, correct?
Yeah, then they took it.
Okay, and then they took it. But my question again was, you're holding a loaded AR.
The AR was not loaded. The clip was in my glove compartment. There was no bullet in the chamber.
You said that you put the clip in the AR.
When they pulled up to me, and I saw somebody have a shotgun, when I saw somebody else have a weapon, I grabbed my weapon. Once I seen another individual had a weapon, I grabbed my weapon.
Okay, there was different individuals. Let's talk about what Mr. Atkins did. Don't concentrate on the others, okay? A lot of things happened that evening with your friends and the people that may have been with Mr. Atkins. Am I correct?
Yes.
I want you just to talk about Mr. Atkins. Did Mr. Atkins threaten you or do anything to take the gun? Or upon seeing it, is it possible he tried to get the gun for safety reasons so no one would get hurt? Isn't that possible? Isn't that just as possible?
No, that is not possible because they had 2 weapons and nobody else had any weapons but those 2 individuals.
But they didn't threaten you with the weapon.
Yes, they did. They ran up to my friend, hit him. The guy ran up to me, pointed the shotgun at my face. He told me to pray for your life.
But that's not Mr. Atkins. I'm asking you what Mr. Atkins did.
Mr. Atkins was standing there. Eventually, he grabbed my AR. When he grabbed my AR, he tried to shoot my car.
Oh, okay.
He couldn't get it racked back, and then they left.
Okay, so you're saying Mr. Atkins tried to shoot your car up with your AR?
He tried to shoot my
He couldn't get it going?
No.
Did you mention that before today in any police report?
I believe I did mention it in the police report.
Okay.
Can we pause just for 1 second? I believe Mr. Chambers has zoomed in response to the inquiry about court-appointed counsel. Did you want to have us pause the proceedings so he can speak to him? I think that's a good idea. Can you make a device available?
On
Zoom? Yes, so that he can go into a breakout room.
Okay.
That's fine.
Just to be fair to counsel who's just coming in, I mean, I don't think that he's gonna get a lot of information from his own client, but of particular interest is the fact that the illegal activity
Did
that
you
I
want
was.
to go into a breakout room, the 2 of you?
No, I can say it on,
Chambers?
I can just say it on the record. The
Well,
illegal-
I think this needs, okay, all right.
The illegal activity specifically is having a weapon with ammunition in a vehicle, and the prior incident with the people at the gas station with having that AR at these locations. Now, he's already testified that this has happened, but, you know, I'll give him an opportunity to speak with counsel.
Okay, since we're putting all of this on the record, does the prosecution plan on charging this gentleman that's sitting in the witness chair?
No.
All right, then, there's absolutely, then we can proceed.
Okay, thank you, Mr. Chambers. It sounds like we do not need you.
Not needed.
Yeah, not needed. We called you just as a matter of precaution.
Thank you much.
Thank you. Okay, please proceed.
All right. I'm trying to make a distinction between a larceny, which is stealing something, and an armed robbery. Okay, I'm trying to make that distinction, so I'm asking you this question, okay? When Mr. Atkins went for your gun, you testified that's because he saw the gun and tried to take it from you, correct?
Yes.
But when he tried to do that, he made no demand for the gun, correct? When he tried to do that, he made no demand for the gun. Is that correct?
I do not remember him demanding for my gun, but
so he had it in his hands before he ever said anything to you. Is that correct?
He didn't say anything to me. He said it out loud. He has an AR.
Okay.
And then went to go grab my AR.
Right. He has an AR, and then he went to grab it. And then, without saying anything or threatening you, he grabbed the AR, correct? And
Yes.
you decided to not give him the AR. You decided to tussle him rather than let him take it. Am I correct?
Yes.
Correct?
Yes.
And then, one of his friends may have done something, but he didn't threaten you with it or say, give it to me or I'll shoot you. He said nothing. Am I correct?
I don't remember.
So he didn't, that you can remember. Is that correct?
I don't remember.
And then he took it from you and left the scene. Is that correct?
They took my AR, fled with 8 to 9 shots, yes.
Thank you. No other questions.
Can you redirect?
No redirect, Your Honor.
Thank you. Mr. Andrews, you may exit the courtroom. Watch your step as you come down. Any further witnesses for the prosecution?
No further witness, Your Honor.
Counsel? Do
No.
you have any? Okay, is there a motion? Yeah, yes.
Your Honor, people moved for a bind over. What we have here is, in fact, based on the testimony, an armed robbery took place of the AR. We show that there were 3 individuals. They were all acting in concert when they showed up, blocked the complaining witness's car. One got out with a shotgun, the other with a pistol, and the defendant in here came out wearing a bulletproof vest. So just because Mr. Atkins was standing in front of the complaining witness while his other, the other people that were with Mr. Atkins, one having a shotgun to the complaining witness's head, that alone, acting in concert, would constitute an armed robbery, which at one point after the complaining witness was threatened to drop his AR, he was tussling with the defendant. He did drop his AR after the gun was pointed at his head, telling him to drop the AR, and that's when Mr. Atkins grabbed the AR and they all left. The complaining witness also testified to hearing 8 shots, about 8 shots go off, one hitting his vehicle. I believe that people have met the burden as far as probable cause go, and I believe it's a question of fact at this point on, if you move for binding.
Counsel?
Your Honor, I would strongly urge you not find this case over. Taking the case in light most favorable to the prosecution in terms of the bind over. What we have here, it's very obvious, is, and the witness testifies that there is some sort of altercation with other people at a gas station just prior to this, and that the witness testified that there was a discussion that precipitated this incident when Mr. Atkins became involved. And that discussion was that it was a misunderstanding. So they had a discussion. That's what this was about. A misunderstanding involving other people at a gas station earlier. It comes right out of the witness's mouth. Now, I can only represent my client in what he may have or may not have done at this particular point in time. But one thing is very clear, that this is not an armed robbery. The purpose of getting near this witness is not to rob him at gunpoint of anything. And when I asked him specifically what was demanded, nothing was demanded. That was his answer. Not a wallet, not an ID, not his car, not anything. There is no armed robbery. And specifically, he testified that only upon him loading up the weapon, he gives us credit, and I appreciate that. He says, that's when Mr. Atkins looks over and sees me, sees the gun, and then immediately comes and tries to remove the gun or take the gun, which is true. And who wouldn't do that? A man is driving around with an 18-year-old in this city with an AR loaded. It's outrageous. It's outrageous. And how he has not been charged, I don't know. And why he's not going to be charged, I don't know. But that's about the scariest thing I've ever heard. Makes me not want to drive to Detroit at 12:30 at night with people with ARs driving around at gas stations just prior and hassling people for a misunderstanding, got into some sort of argument with an AR-47. Sounds pretty darn scary to me. So the question is there an armed robbery? No testimony of an armed robbery. The only testimony is that Mr. Atkins, upon seeing the weapon, went and tried to get it. He doesn't even have the force or fear necessary as a victim. I asked him, were you fearful? No, I just didn't want to have my weapon removed. It'd be the first time in the history of the United States that the item that was being robbed in an armed robbery is an assault rifle possessed by the victim. That's the craziest thing I've ever even heard. It doesn't even make sense. An armed person is going to be robbed. It makes no sense because it's not true. The purpose is only one purpose, and that's to get this gun away from this person who is unsafe. And that's the only purpose. It's the only possible purpose. So in regards to count 1 and count 3, count 3 is the body armor used in commission of the armed robbery, which there is no armed robbery. So I'm asking that counts 1 and 3 be dismissed at this time. Your Honor, regarding count 2, which is the larceny. Larceny is stealing with an element to permanently deprive, which has not been shown. The purpose has not been shown that he permanently planned to deprive this person of this weapon. And that purpose, the only logical purpose, is to make safe. There was a fight, and during the fight, no bullets were fired during the fight, and certainly the gun had already been removed before anything ever happened. By the way, that had nothing to do with Mr. Atkins. So even count 2 would fail at this point in time. I would expect nothing except them to take the weapon away from this lunatic 18-year-old driving around. Because the alternative is to leave him with that weapon. Leave him with the weapon is the most outrageous thing you could even imagine. And that just defies logic. I'm asking that this case be dismissed on all charges at this time.
So we've heard the testimony from Mr. Andrews, and I felt as though Mr. Andrews was very candid in his testimony, both on direct and cross-examination. It's important for you to understand, Mr. Atkins, that today is not a trial. This is not a trial today. Today's called an examination, preliminary examination. So the burden on the prosecutor is to establish by a probable cause standard only that crimes were committed in the city of Detroit, county of Wayne, and that you probably committed those offenses. Now, people talk about, well, the burden is so low here, and generally don't like how low the burden is here, but this is how the system is set up. So until that changes, that is what the court here is to consider. I don't have an option to say, no, we're going to turn this into a hearing that requires a much higher standard of proof. The witness that testified again very succinctly, and with a level of consistency between direct and cross-examination with regards to what happened at roughly 1 o'clock in the morning on the date in question in the city of Detroit. He clearly identified you as the driver of that vehicle and also the individual that was wearing body armor. And the testimony as it was elicited by by the prosecution and the cross-examination testimony that came out, leads this court to believe that while certainly counsel has presented an interesting argument that perhaps certainly can be explored in greater detail, that you were simply trying to make the streets of the city of Detroit safer by going forward and removing dangerous weapons off the street. I don't know, perhaps that there's more to it. Maybe there's more information about what you and your friends do. I don't know. But at this stage, the prosecutor has met their burden with regards to count 1, robbery armed. There was testimony to the extent that the witness did not see you with a firearm when you came out of the car. However, there was testimony that you were with these other individuals that came out of the vehicle, and the other 2 individuals were holding firearms. And so this court certainly does connect the dots to the extent that there's a nexus between those other individuals in the car and yourself. And during the midst of this, the AR that was referred to that was in the car of Mr. Andrews was then grabbed. And there was a tussle that ensued. Now, does that sound very, like a very interesting situation to observe? Yes, that there's a tussle over this assault rifle. But the testimony, again, came out consistent on both direct and cross-examination to that extent. And that when someone came up from behind Mr. Andrews, I thought I heard him say punched him, but I distinctly heard him say choked him from behind and pointed a gun at him and said to drop it, is when he dropped the AR. He said that subsequent, and then the AR was thus in the possession of those trying to take it, and he indicated that some approximately 8 shots had rang out after that. He called the police as he realized absolutely that this assault rifle was registered to him, as he indicated he had just purchased it earlier that day. Now, why he had an assault rifle? Very good question. Very good question. Concerns me. But what I'm charged with doing right now is focusing on the allegations against you and whether or not the prosecution has presented sufficient testimony to, at the very least, present a question of fact that needs to be determined by the fact finder. So as it relates to count 1, as well as count 2, count 3, and then count 4 and 5 that attach to the count 1 and 2, I do find that the prosecutor has met their burden.
Hold on, counts 4 and 5 are not him.
Oh, I'm sorry.
Yeah, the defendant too.
4 and 5 is a felony firearm. Okay, I'm sorry, that's Rodriguez, who we haven't heard yet. Counts 1, which is the robbery armed. Count 2, weapons, firearm larceny. Count 3, body armor wearing during commission of violent crime. The court does find that the prosecution has met their burden. The matter is going to be bound over to the circuit court for further proceedings with an AOI date of August 23rd at 9 a.m. Did you wish to address bond?
I did, Your Honor, and the only thing I wish to address was that my client is no prior criminal record, and everything he had on that evening was he had licenses. I just wanted to bring that to the court's attention. He has no prior criminal history. He is tight eligible if this could be worked out. So all that is in his favor. We wanted to move the case along, but he is a resident and he has an apartment in Toledo. And I agreed at an earlier hearing for the tether that he would be in Lincoln Park simply until you heard the evidence. And he has been perfect on the tether. But now I'm asking Your Honor to especially given the fact that somehow new counsel got in on this case and pushed their exam off to October. I just want to bring that to your attention, to have him sit around in Michigan for this long. I think he's proved to you in this time that he's fully compliant. And I'm asking the tether be removed and he allowed to go come in for his court hearings and allowed to go back to Toledo, which is his home. As they said, he's height eligible with no prior.
Prosecution?
So I don't understand, is the defense counsel, are you asking to remove the tether?
Yeah, that's all, and get permission to go back to Ohio and come in for his court hearings. He has a job and his family is there.
I will say typically, leaving the state and only coming back in for court hearings typically is not something that is.
He turned himself in on this case. I want to, this is something he's not hiding. He has a real motivation to show up here.
Yes, and I understand that, but typically it's, what I would say is I'm not comfortable with making that alteration to the bond. But certainly that does not thwart the circuit court judge from making that modification to the bond. But at this point, I have not only bound it over, but for there to be a release to a different state, but only for it to come back for the hearings, I'm not comfortable with it.
All right, let me renew my motion and just ask that the tether be removed. And he'll continue to at least stay in the home so we can at least get a job. This case is going to take a while now.
Yeah, this case was gonna take a while, whether the co-defendant got pushed to October or not, because, and I know a lot of times the conversation is not being had. I don't mean to suggest you're not having it.
Yeah.
But most people who come before the court don't realize how the pandemic has affected things. So whether you had waited until October or not, there is a tremendous backup across the street. So I don't want you to think that any delays have been because people don't want to hear your case. The courts have been shut down. So,
Could you have the tether removed though?
Madam Prosecutor, and there's a level of familiarity apparently between the defendant, Mr. Atkins, and Mr. Andrews. I don't know to what degree, but the tether is generally put in place in order to protect the safety of the community as well as, in this particular case, Mr. Andrews.
That's correct, Your Honor. Can I ask?
Yes, yes.
Your Honor, can I say something?
No.
The complaining witness does not feel safe with no tether.
The tether is going to remain, but I am going to reemphasize that on August 23rd, the circuit judge can absolutely modify the bond, remove the tether, and can certainly even allow you to go back to Ohio if that is what their druthers are. But at this particular moment, I am not comfortable with modification of the bond now that the matter has been bound over. Again, the arraignment on information date is going to be August 23rd at 9 a.m.
Thank you.
Thank you. All right, this goes back to you. I see there's an emergency motion here